So I'm Nate Downing. I'll be moderating this panel. They're the experts on this panel. I'm here to ask questions. So if you have a question, you'll be wanting to hear from them. But I work at Gardner Law. I'm a managing attorney. I lead the regulatory practice and have a really big focus, obviously, on FDA. Also touch on some EU things. And there's such an intersection with privacy in the way you got to get products on the market, encompassing compliance, regulatory, and privacy, that the full scope of today's program should give us a great launching point for any topic that we might have related to this information. And I'm going to hand it off to each panelist to introduce themselves.
There we go. Good morning. Hi, everyone. My name is Paul Rothermel. As Nate mentioned, our practice at Gardner also emphasizes privacy and AI in that respect. So artificial intelligence, as you know, is a significant area. And so we'll be talking about that from a US perspective, from an EU perspective, and UK perspective. My practice largely is focused on privacy, AI, technology matters, cybersecurity as well. So things like HIPAA, the state privacy laws, CCPA, which is very relevant here in California, but also many other state laws that impact how we use and handle data.
Oh, thanks, Paul. I'm Felicity Fisher. You'll see everyone refer to me as Flick, and you're welcome to do the same. So like Paul, I'm a sort of privacy and digital regulatory lawyer, UK qualified, but help run our Silicon Valley team. So Fieldfisher is a European kind of headquartered law firm, but some of us are lucky enough to work out here in our Silicon Valley office, and I'm one of the few partners that runs the team out here. So I spend my days advising our US clients on kind of European, UK privacy, digital regulatory matters, and that at the moment involves a vast amount of counseling on AI related matters. So very much looking forward to this discussion.
Thanks, Flick. Hi, everyone. I'm Oliver Süme. I'm with Fieldfisher as well. I'm a partner in the German office and co-heading the technology sector practice of the firm. I'm doing technology and privacy data protection law for more than 20 years now, in particular with many clients from the life science sector, medical device companies, and well, what keeps me busy currently, AI, that we will have on the panel here today, is a huge topic, in particular from a European perspective. We have a very strict regulation, as many of you might heard. And that combined with the strict requirements under GDPR is a challenge and confusing sometimes, and I'm trying to help my clients out of that. Thanks.
So as we kick it off, we're going to do like a Q&A session, right? But there's also some slides that you'll see, and those are really good information. So in your packets, you can refer to those, review those if you have questions. Those are really a great, information. But here we're really looking to have a discussion, so that's why those slides are included. So I'm going to ask a panel the question, and this is going to cover US, EU, UK. How is artificial intelligence defined in the UK, EU, US, and where does that definition stem from?
I think I'm going to let the EU side respond to this first. It's a little more clear in that area.
I have to read it to you because it's really kind of funny. So under the AI Act, an AI system means a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that explicit or implicit objectives infers from the input it receives, how to generate output such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So no one really understands what that means, and that, to be honest, leads to a lot of uncertainty. It still refers very much to the definition that is also used on the OECD level. So that was the goal, to keep like at least an international global approach when defining AI. But still, and you hear it from the definition that I read, it is very, very broad, and a key question, of course, if a certain system is considered as AI, with the consequence that it falls under the scope of the European AI Act, or on the other hand side, if it's still just usual software, which would mean that it's not regulated. And that is, well, so to say, the entry gate of the whole act is already providing for some uncertainty.
Yeah, and from the UK perspective, you'll see as we kind of get into the discussions that the UK has taken a very, very different legislative approach to regulating AI. So we don't have an equivalent of the AI Act. And the UK government has very much pushed an agenda of we're going to have a principle-based approach and a flexible based approach to kind of regulating AI. So they are very much positioning their approach as pro-innovation, particularly compared to what's seen as a very regulated approach coming from the EU. And aligned with that sort of approach of not having a sort of equivalent of the AI Act, we've got quite flexible definitions of what AI is under the UK kind of guidance and principles. But essentially, they're talking about machine learning type technologies that are there to replace kind of human processes and decision making and things like that. But aligned with their approach, it's very much looking at the type of scenario that you've got, the type of use case, and the risk associated with that particular AI use case, as opposed to strict definitions.
And I guess we're on a little bit of a spectrum here, going left to right. So as you look at the US definitions around AI, primarily we're looking at state laws. And so far, there's not a lot of those that address AI generally. So we see some generative AI regulations, for example, in California, and those rules focus on particularly things like ChatGPT, Gemini, these other tools that are used by individual consumers that are used to generate text or other things. But there is a focus in many of the privacy laws on automated decision-making technology, which touches on AI. It's not exactly the same as AI, but it gets into that realm. So we see some regulation around that. Particularly California has released some regulations on automated decision-making technology in particular. And so that influences a kind of technology that makes significant decisions without human intervention for individuals who are, whether it's provision of healthcare, denial of healthcare, different things that can impact them. So the definition there is more about the use of that technology and how it's deployed. And then in Colorado, we have a definition of AI within really the only general AI system law in the US right now that really is similar to the EU AI Act. In a way, it's a little bit lighter on text. And as Oliver said, I don't think I could quote it from memory, but an essential part of that is that it influences virtual and physical environments through the use of these technologies. So it's a system that influences environments in some way. So there isn't this sort of narrow focused, here's an AI system. It's kind of a broad, intentionally, I think, definition that's designed to capture some ambiguity in future technologies that we may not understand yet or be able to point a finger to yet.
Yeah, and I think it's also worth saying, I think the Californian rules that have come out have been inspired by the European concepts of automated decision making. So under the GDPR, we specifically regulate automated decision making that has a significant impact or legal effect on individuals. So we're really looking at sort of algorithmically driven decisions or AI model outputs that could really have a significant impact on people's kind of rights and freedoms or their access to healthcare or perhaps clinical decisions that are made about them. And that's quite clearly regulated under existing privacy laws in both Europe and the UK. It's Article 22 under the GDPR. And if you're doing that type of automated decision making, then essentially the law says you're prohibited from doing that unless you meet certain conditions. So it's kind of a slightly different to the Californian approach, which is you can do it provided there's pre-notice and some kind of opt-out. In Europe, it's a slightly higher bar under the GDPR for enabling that automated decision making. We're starting to see more and more scenarios, particularly around clinical decision making, where we're falling into that automated decision making and then it gets regulated. And lots of that decision making is powered by AI now. So it kind of pulls AI into that scenario.
Thank you. So as you're starting to develop a product, if you think you might have AI elements, you can already see across 3 different jurisdictions the kind of work you have to make sure you're properly defined. Let's take that a little step further now. How is AI regulated for a life sciences application versus more of a general application? And what is the impact of that to industry?
So the European AI Act basically takes a risk-based approach. And the principle is the more risk-based a certain AI technology is, the more compliance requirements you will have to meet as a provider or deployer. The interesting thing about the life science sector, and in particular medical devices, is that as soon as a medical device has an AI system embedded, it will always be considered as high risk, which means not only that you have to meet the highest requirements under the European AI Act, but in particular, you need to undergo a new certification process, a conformity assessment. And that is something that, well, keeps the notifying body very busy currently. This part of the AI Act will only be applicable from August 2027, which seems like to be far away from now, but it will take time to get the new assessment and the new certification. So yes, for medical device manufacturers that are using AI within their technologies, it's really challenging, and we're always advising clients to start their internal assessments as soon as possible.
Yeah, I think a key part for life sciences to keep in mind is when you're looking at these laws, many times they're not designed with life sciences in mind within the US. So we have, say, Colorado's AI Act right now, which has been delayed, and the effective date of that for enforcement is out into June 2026 now. But when you look at those laws, what they do provide is usually an exemption for, in Colorado's case, specifically for something that's been approved through a substantially equivalent or similar process within federal law. So we have, by a federal agency. So we have some ways to look at, does that mean all FDA approved products, or is there some, like similar to the EU, some overlap where there may be some additional steps to take to address those AI laws within the state? Similarly, when we're talking about the automated decision-making technology, if you're looking at what is a significant decision for an individual, provision of healthcare, does that cover life sciences applications? Probably some of them. So there's some analysis that needs to be done to address when a life sciences application of the law does impact those products.
And then just to kind of complete the UK perspective on this. So as I mentioned, we don't have an equivalent to the AI Act. And in fact, post-Brexit, we're dealing with medical device regulations that are dated back to 2002. So quite an outdated set of regulations there in the UK. And so what the MHRA, which is the sort of regulatory body for medical devices in the UK, they have been tasked through the UK government's kind of policy approach of coming up with principles, guidelines, and regulatory reform to kind of specifically regulate AI in medical devices and software as medical devices within the UK. So they've got an extensive kind of roadmap that they have laid out and a plan for kind of better, I guess, supporting and providing guidance and processes around how we kind of regulate AI in medical devices moving forward. But it's quite a different approach to Europe. So we're sort of waiting for them to publish quite a lot of their guidance. They're trying to align more internationally with more international standards than Europe. But essentially, if you've got an AI tool that has a medical purpose that is involved in kind of clinical decision making and things like that, then it's going to be regulated within the existing regime, and therefore we need to look to the guidance that comes from the MHRA around how we sort of integrate AI and use AI in a compliant way.
Yeah, I think if you look on the screen right now, it's showing the growth of AI. This is FDA focused. But you can see there's ambiguity, but it's not like products aren't getting onto market, right? So some of your regulators certainly have experience, they know how to move it, but it's not always well defined from a top level, right? So it takes a lot of work to figure out how to define your product, what's going to be required to get it on the market. And I'm going to ask a question for the panel that brings in privacy and data protection and all of those things. So there's a lot that's being done, but there's also more that can be done to make it easier on industry to have predictability and to really know the path to take. So you know, that's a great slide just to show it's going up and it's going to continue to do so. though we're not always up to speed from a regulatory standpoint, rulemaking, lawmaking, that type of thing. How do data protection and privacy laws interact with the use of AI?
Yeah, that's a very good question. And exactly that is the challenge for many companies also beyond the life science sector, because of course GDPR still applies. And if you know some of the basic principle of the GDPR, you of course understand that it seems to be a little bit of a conflict maybe because, for example, the GDPR knows the principle of data minimization. You're only allowed to use as much data or data processing of personal information that is really needed to fulfill a certain purpose. And that actually more or less is contradicting what the basic of large language models is, because the more data you have, the more data you can use, the better the outcome of a large language model, for example. And that's really what is challenging. Yeah, you need to comply with both on top of what is regulated under the medical device regulation in the EU. So it's really a challenge. And in that respect, I must say the AI Act is a bad regulation because it does not clearly define the overlap between GDPR and AI Act. It leaves it to the industry, if you will, to think about how you can solve this. It's really challenging.
Yeah, I think there is an inherent kind of conflict that's emerging between the requirements around, good AI governance and thinking about the types of information that you use to train, validate, improve models requires often a vast amount of data. And in the medical device life sciences space, we often need sensitive personal data to properly train some of these models. And that leads into a conflict with European data protection law, where the general rule is we're not supposed to be using sensitive data unless we can meet certain elevated compliance requirements, and some of them are quite hard to meet under the existing kind of conditions that apply there. So the UK has been trying to sort of improve on its data protection laws through some targeted amendments that have just come out in June, actually, through the Data Use and Access Act. So post-Brexit, we're now free to legislate independently of Europe, and in line with our approach to try and sort of be a centre of excellence for AI and a place of real, to really encourage innovation in the AI space. We're kind of seeing that come through in some changes to the UK GDPR. So more recently, well, in June, some of those changes include sort of more permissive rules around secondary use of data for research purposes, for example. And so we could start to see through the divergence in the UK regime a little bit more flexibility around how we use some types of personal data for research and relatedly kind of training and improving AI models. And I did notice as well that we've got the digital omnibus kind of package that's been released, well, is due to come out on the 19th of November. That's a package of reforms, targeted reforms that Europe is looking to make to some of the existing package of regulation in Europe. And interestingly, I saw sort of word on the street that they're thinking of introducing some changes to the GDPR to allow a more expansive view on what counts as a legitimate interest for using personal data to train AI models. We might, there's a long way to go through some of those change suggestions, but we could start to see them make some changes to better support the use of data for AI-driven innovation.
Yeah, I'd say in the US, one of the areas that has gone relatively well, I think, for life sciences is that we have HIPAA and these other laws that can provide some certainty as far as when you're going through the clinical research, you're developing a study, you're sponsoring that study. Typically that data, if you do the consents properly, if you do the agreements in a way that allows for it, you can do a lot with that data without some of the restrictions that we might see in a European model from a data protection standpoint. I think outside of those particular kind of healthcare, we have the data through a research study. Outside of those environments, it can be more challenging. We see a lot of different, the patchwork of US privacy laws can be very tricky when you're dealing with things like consumer data or direct to consumer information that's not part of the HIPAA bubble, if you will. So that is where we see the rubber meet the road in terms of when is consent required to use AI? What does de-identification look like outside of HIPAA within these state privacy laws? And so that can be a challenge. We typically are seeing a variety of different approaches there. Often de-identification is the goal, but the standards are not as clear when you're outside of the HIPAA realm.
And actually, sorry, just to make one important point there, actually, because I see it come up a lot, which is the kind of standard for de-identification under HIPAA is quite different to the standard for anonymization in Europe. Unfortunately, for lots of research scenarios, our standard for anonymization is a lot higher. And we also have this kind of separate bucket of data, which we call pseudonymized data, which is essentially our version of the HIPAA de-identified data. And we still treat that de-identified data as personal data, and so it still remains regulated. If we want to anonymize data and to take it outside the scope of the law and therefore have fuller reign or freer reign over how we use it, we're talking about meeting an incredibly high standard, which is in practice often makes the data less useful. And so there is that battle there as well.
Yeah, interesting. I think, the next question is really something that kind of gets to the crux of the issue of the way we're all speaking right here, right? There's different regimes, different ways of doing things, but that doesn't help companies who have to make one product, right? Now, understanding the knowledge of, but the way EU, UK, and US work together isn't helping companies. And so are there challenges or best practices for harmonizing compliance across regions, dealing with privacy, AI regulations that are different from each other? How can companies really be impactful, efficient at actually getting these issues and tackling them head on so they can have some predictability in the time to market and to the protections once they're on market?
Yeah, from the US perspective, I would say often because of the really enormous differences between particularly HIPAA and how that data and how it's applied to companies in the US and the EU standards, we're typically seeing companies separate some of that activity. And so it's very difficult to harmonize it internally. There's just very different rules. The data that's subject to those rules is different, and the impact can be challenging. So we see a lot of companies diversify and separate those functions, at least from the US perspective. Beyond that, I think the state rules have thrown another wrench into that, but I think to a degree, those are at least a little bit more harmonized with EU standards in terms of typically secondary use is handled the same way. The coverage of that data is a little bit broader. So it can be a challenge. It certainly can.
Yeah, I think one of the things you can note across the different regimes is there's obviously quite a lot of divergence in how we specifically regulate AI and how we regulate the processing of PII or personal data. But if you look at it from the perspective of some of the risks that we all need to be thinking about when we're integrating, building AI tools, a lot of those principles are kind of common across the regimes that we need to be thinking about. These concepts of transparency, explainability, safety. So actually, one of the things that you can start to do is think about an AI governance program that starts to tackle these principled level requirements that are going to hit a lot of the issues that you need to be thinking about under lots of different regulatory regimes. I think a starting point for that is actually understanding what AI you're using, building, developing, integrating, because only then can you start to get a handle on what you need to do to kind of implement the right kind of compliance. So I think it all starts with some kind of important internal inventory and mapping exercise, and also thinking about what principles you as an organization need to stand behind when you're using AI within your organization, because a lot of that's going to be driven by regulatory requirements, but there are also emerging kind of governance frameworks and principles that apply across different legal regimes or that are common to them.
Yeah, no, very good point, and that's exactly what we see at many clients happening currently as well. AI governance is really the key project here for many companies. And that means, of course, understanding your own processes in a first step, and have an assessment to what extent you might already have AI in different departments of a company. And the bigger the company, the more international, the more complex is this challenge So it's really an internal assessment, internal homework that you need to carry out. And then, as Flick rightly pointed out, think about how do I integrate a new compliance structure into my existing compliance structure in the business? Will AI governance be part of my legal department? Will it be part of my compliance department? How do I create a policy that is dealing with how my employees are allowed to use AI or not, to what extent? That's something that I think is a really fundamental homework that every company, regardless of the sector, actually needs to carry out currently. And what might be helpful from a global perspective are the OECD principles on AI governance. So that is something that we see as a global approach. It's of course general, but we see some, well, global principles that are the same. It's all about transparency. It's about documentation. It's about compliance. And that can be, so these principles might be a starting point for developing a global internal AI governance structure.
That's great advice. You've got to be able to integrate everything and just make it part of your culture. We do have an online question, so Paul, go ahead and make your statement. I'm going to walk over, but just a reminder too, in the room, if you have questions, feel free to ask. I'm going to do an online question during Paul's comment, then I'll swing over to you.
Yeah, I was just going to add, I think that's a really good point, that despite essentially the lack of or light regulation in the US on AI specifically, it can't hurt, and it certainly companies are looking at AI from a risk management standpoint, and how do we ensure that while it's not necessarily a regulatory issue in every state or in every case, we still need to consider some of these risks, and those risks are, potentially patient harm or misinformation that the company may produce or use internally, IP issues. There's a variety of concerns with AI, that privacy issues, of course. There's a variety of concerns that need to be addressed, whether the regulations require specific programs or risk assessments or not.
All right, so we have a couple questions online. The first one is, because the EU AI Act is horizontal and extraterritorial regulation, does it imply that this law is applicable to the US and UK and across other regions if you intend to supply or put in place your AI products or systems? So I think the question is, if you aren't located in the EU, but you intend to sell your AI product in the EU, does it apply to you?
The answer is quite easy, yes. No, it's the AI Act takes, like many European regulations, an extraterritorial approach. So it applies to every company that wants to place systems or products on the European market that, in this case, imply AI systems.
Great, thank you. And one more. I think this is for Flick. To your comments about a difference in research data and the slides breakdown of clinical chemistry, are there developments in using AI in the R&D space that complement clinical trials? For example, pharmacopoeia compliance testing, or is the focus here just clinical data?
Well, so the focus of the UK data protection laws, like the European data protection laws, is on the processing of personal data. So we take a technology neutral, sector neutral. It's all about processing personal data, and we have particular provisions in the law that deal with processing of personal data for research purposes. And for a long time, certainly under the EU GDPR, there has been a bit of a battle over what counts as scientific research for the purposes of some of those provisions. And we've now got a little bit more guidance from the European side, which takes, I think, a slightly more restrictive view on what counts as scientific research versus what we're starting to see come through from the targeted amendments to the UK data protection laws. So slightly, they've put on a statutory kind of footing acknowledgement that certain, privately funded research activities, commercially focused research activities, anything that can be reasonably deemed scientific is now going to count as scientific research. And that has some particular implications, because it now means that we can, if we are doing scientific research, we can start to take advantage of some of the wider, more permissive rules around using and reusing personal data for scientific research purposes. So naturally, that is going to play well, I think, to anybody who's doing kind of clinical research. And yeah, so I hope that answers the question.
Thank you. We do have one question in the room too, so I'm going to hand the mic over.
Hi, everyone. This is a little bit of a leading question for Flick, because I actually have worked with Flick a little bit, but curious if you could all opine You talked about the different regimes and the challenges with, what regime you're going to be operating under. But if you're a global company, how do you go about defining terms? I mean, on a very basic level, I know we've talked about when we talk about personal health information in the US, that has a certain definition and a very different definition in the UK and the EU. So how do you advise clients? How do you go about operating? At what basis do you just try to say, hey, these are the words we're using, and these are the definitions we're using, and then from there?
I'll let someone. I can give you my answer, Alex, but you might want a different perspective. So do you want to answer?
The challenge actually is to find the lowest common ground for definitions, and that's where where available, global principles can help. I was referring to the OECD AI principles earlier. With regard to, well, the different privacy, data protection, GDPR laws, it's more challenging because, as you rightly said, the definitions about what has to be considered personal information under the GDPR compared to HIPAA is not completely, but significantly different. So yeah, that's the more challenging part. I would say, actually, with regard to the AI principles, it's a little bit easier compared to definition of personal or health information.
Yeah, and I would just add to that. I think it's very difficult to come up with a sort of global set of, if we're focused on data protection issues, for example, a global set of data protection terms. We've partly because Europe is very prescriptive about what terms we have to have in place. If, for example, we're a data processor, we know we have to have a data processing agreement in place. If we want to start reusing our customers' data and we're a processor for secondary purposes of, improving our AI models, that then has certain implications because we switch from being a processor to a controller. And so that then requires specific terms to address that ability to wear a different hat for that secondary use. And because we then have different definitions of de-identified data under HIPAA versus the anonymization standard under the EU, I think you're putting a lot of pressure on a set of terms if we're trying to come up with just a blanket set for everybody. So the reality is, and you'll see this across many different, even outside the medical device space, just looking at a standard SaaS solution, you end up having to have a particular set of data protection terms in the form of a DPA, a data processing agreement for Europe. You can then start to layer in, CCPA and other requirements into that DPA if you need to. But you might need to take a slightly different approach to some of the, data use rights for Europe versus the US, depending on what you're trying to do, if you want to take advantage of a more permissive regime in the US versus the EU. And that comes up a lot at the moment because everyone is on a data grab to grab personal data to train their AI models or improve their AI tools and technology. And the US may be more restrictive or maybe more permissive, and so you can get more data and use it, whereas in Europe we have to meet stricter conditions. So you start to see people, well, we might need to take a slightly different approach with our European customer base versus our US.
Yeah, really good points. And I just add to that, I think, as you noted, so let's say you're signing a business associate agreement and one of your goals is data reuse. To add to what Flick was saying, there are some issues with that, right? So you've agreed typically to only use the data in performance of the agreement for the covered entity, essentially the controller, if you look at it from that European perspective. Well, there needs to be specific terminology to allow you to de-identify that data and then have authorization for that. And then further, well, AI, that's a whole nother use. A lot of agreements now try to limit that kind of activity, even in the US, when it comes to these processor, these business associate relationships. So we're seeing more restrictiveness, and it flows down through those definitions. What is PHI? What, is it subject to this agreement or that agreement? And it gets very complex, and it's difficult, like we are all saying, to use a single set of terminology globally to try to address these laws that start to diverge in what's required.
Thank you. In our last 5 minutes, we do have time for about one more question that's online already. So I apologize to some questions we may not be able to get to. And then I'm going to have a final question for each of you, and then we'll pass it to Cord and Amanda.
All right. Can you speak about the difference between internal development and the use of AI and the meaning of placing on the market in terms of the EU AI Act?
Yeah, that's actually a fundamental difference. As long as it's only for internal company purposes, that would not be considered, even though the company is operating in Europe, that would not be considered as placing on the market. So placing on the market really means launching a product for clients for external use. So internal AI deployment or development would not be covered.
And that would also cover internal research and development, which I think is really important for lots of this audience as well. So if you're using your AI system for your internal research and development, that might be outside the scope of the AI Act.
I'd like to thank Paul, Flick, Oliver. Great conversation. Really important, obviously, in today's age, the ability to have a little bit more predictability when dealing with AI products is important. So I hope this conversation helped. I'm going to give you each one more minute to reply. Where do we go from here? What does it look like? What does the future look like from a regulation standpoint on AI data privacy? I know minute's not enough, but some high level thoughts on where do we go and how does it get better?
You know, I don't think there's any easy way to predict where the US will go, but the signs have recently been probably no national regulation on AI directly, at least at the general level. We might see some things to protect children online, things like that. Those seem to have some legs within a bipartisan approach, if there's anything that's bipartisan right now. But yeah, generally I would expect not to see federal regulation. And so what we see typically then is the states, particularly California and other larger states with interest in this area, are starting to try to fill those gaps that they see. So we're not seeing a likely federal solution at this point.
Yeah, from the UK. So, I mean, it probably hasn't gone unnoticed that AI has also become a very politicized issue as well. And I think there's a huge momentum in the UK to make the UK a kind of center of innovation for AI. And so we've had the UK AI action plan, and more recently they've had a life sciences kind of plan come out. And it's very, very clear that they want to be, the UK wants to be a center for innovation, particularly for the life sciences space in the AI space. So I think that's going to feed through into their regulatory approach, which we already know is a much more, they're going with a much more flexible approach to it. But I think we're going to see, you know, more guidance, more secondary legislation from the sort of dedicated regulators like the MHRA will be driving some of that regulatory reform to better kind of clarify the scope of some of the requirements in the UK. But I think for various reasons, they are going to go with a more permissive regime than Europe to try and capitalize on some of the advantage of that sort of pro-innovation strategy. We've got this new changes to the UK data protection laws that need to be sort of bedded in with secondary legislation over the next year. The ICO, now going to be called the Information Commissioner, that's our UK regulator, is updating all of its guidance on things like processing personal data for research purposes. So there's a huge amount going on in the space at the moment in terms of regulatory reform, updated guidance, all with the goal of making the UK a centre for sort of AI innovation.
I would really say implementing an internal AI governance structure is the best advice currently, and that's what we see in the market, and that's regardless of any details of the UK or European or Colorado regulation. That's really the challenge, because AI is a compliance topic. It's also a risk topic in terms of cybersecurity. Artificial intelligence as well provides completely new opportunities for hackers, for attackers. So it's also a very important IT security topic, and that all needs to be covered by a new, well, AI-specific compliance infrastructure within a company. And that's what would be my recommendation and advice. Work on that and look who's responsible, who has the know-how, and who also has the power within a company or group of companies to enroll and enforce an internal AI governance structure.
Thank you. I'd like to thank you for this informative panel, and I'll welcome Amanda and Corda.
Hello, this is good? Okay, great. Hello, good morning. Good to see so many familiar faces and new faces. Happy to be here. My name is Amanda Johnston, and I'm a partner at Gardner Law. I lead the compliance practice. So today I'm going to be giving a brief compliance update on everything that's been going on in the US. And I guess, let's see. I'll start with just, I'd be remiss not to mention the fact that our government is shut down still. 36 days and counting. But so from a DOJ perspective, they have furloughed 10% of their staff. We understand that civil prosecution and investigations are generally on hold. However, criminal FBI type investigations and prosecutions are still proceeding, as we understand. CMS, they've reported that half of their workers have been furloughed. We've seen, I know a couple companies have seen some activity out of CMS, but then some gaps elsewhere. And we'll talk a little bit about FDA later, but they have about 14% of their staff on furlough right now. And they're not accepting submissions, which is affects a lot of companies here, I'm sure. So 2025, so I know it's November, so we're almost to the end of 2025, but wanted to just take a minute to look back and then also think ahead. You know, what are we looking at in the future? What are we looking at? What should we be paying attention to today and in the months ahead? So wanted to mention, so one thing that we'll talk a little bit more about, but the DOJ and the Department of Health and Human Services have relaunched their False Claims Act working group as of July. So this is a working group that was originally initiated in 2020 under the first Trump administration. They've announced a reinvigorated working group with some priorities that we'll talk through. And why it matters, really, because there's some new kind of pricing and contracting is one of their priorities that hasn't gotten a lot of direct attention. We've seen it come up sometimes in settlements from a discount perspective, but it is something that pointing out as something to keep an eye on. They're really doubling down on their intention to use data and analytics to drive investigations. And they have reminded the industry that they expect companies to be doing the same from a compliance monitoring and auditing perspective. So from an enforcement landscape, we continue to see very aggressive focus on healthcare fraud, primarily kickbacks. We are seeing, as the working group has prioritized, but we're definitely seeing more data-driven analytics. So the government is using data to target high-risk industries, high-risk companies. They're looking at CMS data, open payments data, claims data. They are trying to be very smart about where to invest their investigation dollars. Whistleblower risks continue to be at an all-time high. In fiscal year 2024, there were 979 qui tam lawsuits filed. That was the highest ever in history. And there are a number of programs that the DOJ has initiated to incentivize whistleblowers. So more than ever, there are lots of incentives, both monetary and in some cases being excused from prosecution to actually blow the whistle, whether you're a former employee, internal employee. It's definitely something to keep an eye on. They're also really focusing on coordinating across agencies, which makes sense from an efficiency standpoint, but FDA, FTC, CMS, DOJ, and OIG, they're all talking. So FTC, FDA, CMS, they're looking at potentially sharing data amongst each other and then working with the DOJ as necessary to actually prosecute or investigate. One of the reasons we will continue to see an aggressive DOJ enforcement focus on the False Claims Act is because it's very profitable for them. It makes up, so they collected $2.9 billion in fiscal year 2024 on False Claims Act settlements or recoveries. 70% of that was from healthcare. So it's a big part of their budget. It's bipartisan. Healthcare fraud, nobody wants healthcare fraud. So it's not going to be going anywhere anytime soon. And there's been a rise over the last 10 years or so focusing on individual accountability of executives. We anticipate that will continue as well. They want executives to be held accountable for the actions of their company and the decisions made because of their position in the company and their responsibilities. All right, so I'm going to go through a few enforcement trends, both from an anti-kickback statute and a False Claims Act perspective. So just from the last year and a half or so, these are kind of the main themes that we've drawn. So if you're familiar with the Teva Pharmaceuticals settlement, that was the largest settlement related to charitable foundations, $425 million. So the government is still looking at charitable foundations. They're, they need to be structured carefully. There's a couple of advisory opinions on point. There's special bulletins outlining safeguards and mitigations. So if you are looking to do a charitable foundation or any type of charitable where money is going back and forth and potentially going to patients, that's considered a high risk area. Make sure that you're looking at the advisory opinions, special bulletins to try to structure it to mitigate risk. We continue to see more of the garden variety AKS. So there was a Pfizer and a Gilead settlement this year, again, focusing on honoraria that exceeds fair market value, paying doctors too much. High-end meals continues to be a topic, top shelf liquor. Again, those were both covered in the Pfizer and the Gilead settlements as well. And we've seen a resurgence on the focus of speaker programs. So if you recall, there was a special fraud alert a few years ago. They've now had a handful of settlements, again, on speaker programs, really focusing on the same suspect characteristics that were in the fraud alert. So repeat attendance, so same person attending multiple programs, that's a risk factor. A content that lacks educational value, so making sure that if you're having a program that you have true educational value, there's true educational objectives. Repeat program content, so having the same program over and over. Lavish venues, so choosing, a fancy place to draw attendance. And then poor controls really was cited in a couple of I think it was the Gilead settlement specifically, is that they failed to put controls around their speaker program. And had they had them in place, they probably would have detected some of the overuse or the high volume of repeat attendees and repeat program content. Gilead also had in the case high use of the same HCP consultants. So they really focused in on certain consultants had really high, like overall over the year. For example, there was one HCP consultant that was paid $300,000. And so really looking at kind of the totals to see where you're at. Commission-based contract sales rep is still very common in the industry. We had a case a few years ago that had identified it as being a suspect arrangement, potentially violating the AKS. We've had a couple cases now this year that have held that it is not per se illegal or not per se a violation of the AKS, but it's still risky, and there are some safeguards that you'd want to implement. We help clients try to tailor their arrangements and policies to meet those safeguards. All right, so False Claims Act, and again, these kind of intersect because if it's an AKS violation, it's also a False Claims Act violation. But we've seen quite a few off-label promotion cases being prosecuted or settled, prosecuted or investigated under the False Claims Act. So not necessarily FDA false or off-label promotion, but the government takes the perspective that the company promoted the product off-label. Had they not done that, they would not have received claims for payment from a Medicare, Medicaid perspective. And we've also seen reimbursement support programs being pulled into that theory as well. So because they promoted off-label theoretically, and their prior auth program helped secure federal funding, that is in turn a False Claims Act violation. We've seen a rise in some safety, so patient safety device use cases under the False Claims Act. So the theory there is, had we known that the device was unsafe or being promoted to be used in an unsafe manner, we would not have paid for it, hence it's a false claim. We're seeing telehealth and like genetic testing in particular has been a hot topic and continues to be. They really focus on kind of the rubber stamping aspect of telehealth. So if you are using or partnering with a telehealth company, that's definitely something to look at. I know a lot of companies are looking into that now, just with the rise of how common telehealth providers are. Medicare Advantage, so we are in Medicare enrollment season right now, but there's been a number of cases and investigations related to brokers steering Medicare beneficiaries to certain programs, and that's definitely a priority. And then kind of the garden variety, improper billing, medically unnecessary services, making false certifications to the government, and cybersecurity vulnerabilities. Excuse me. All right. And then I know we have just a couple minutes left. I wanted to go through just briefly the False Claims Act working group, what their stated priorities are. So if you're gonna, come away with a checklist of things to pay attention to from a compliance perspective, this would be a great place to focus. So Medicare Advantage, again, probably not a lot of attendees here are in kind of that Medicare Advantage space, but you obviously have customers or patients that are Medicare Advantage beneficiaries. Pricing is kind of the big newish one, I think. So they've stated their focus to be discounts, rebates, service fees, formulary placement, and price reporting. So really analyzing your pricing structure, pricing arrangements, making sure that you're fitting within the discount safe harbor or the GPO safe harbor. I recommend looking into that for your company. They also have stated that they're looking into barriers to patient access to care. So this is generally from a discrimination perspective. So hopefully, ideally there's not going to be companies or medical device companies that are having to interact with this, but it's more for kind of like the payers and the Medicare Advantage pieces. Kickbacks, of course, are always going to be on the docket. Defective medical devices that impact patient safety. So again, this kind of goes back to unsafe use, improper promotion. And then a newish one, which I think is interesting, is so they call it the manipulation of EHR systems to drive inappropriate utilization. But really what they're talking about is the use of templates or autofill capabilities within your EHR system to help build the medical necessity criteria. So it will be interesting to see how that plays out or what types of activities they're concerned about specifically. And I guess the last three are just, again, reiterating the cross-agency collaboration. They're talking to each other. They're doing data mining. They're sharing data. And they're going to continue to encourage self-reporting and whistleblowers. And I think there's a question online. So
Yeah, we have one question online where can you please expand on contract sales force and how that, when they're incentivized by commission, what is that? What are the risks there?
So technically, if they are incentivized, or I guess if they're compensated based on the volume or value of sales, it cannot meet the personal services safe harbor under the AKS. And this has been, again, it's a common practice across the industry, especially for smaller companies. They can't hire full-time employees. So the risk is that if you have that type of compensation structure and contractor role, that it doesn't meet the safe harbor. So we've had a case, Mallory, from a few years back that had held that it did violate the AKS, having a volume-based compensation model. But now we've had a couple courts that have not disagreed, but at least have said it's not a per se violation of the AKS. So what we typically do, there's risk there still. We typically help clients structure safeguards, mitigations. So like putting in place training controls over the contractors to try to mitigate risks as much as possible, but risk still remains for sure. And just quickly, I won't go through all these. Like I said, I would focus on the 6 working group priorities. These align well with them. HCP engagements still. Hotline reports, I've noticed that they've been up across the industry. If you get them, and you probably will, take them seriously, investigate promptly, take corrective action, be consistent, document everything, and use use AI, use data analytics. The government's using it, so they expect you guys to do that too. Some specific things to look at, but just generally, I recommend kind of aligning your risk signals with what they're looking at. That was a lot to fit into 15 minutes. All right, I'll hand it over to Cord.
Amanda, thank you very much. I'm now very happy to go back to the other side of the Atlantic and to give you a compliance update. I have to hold the microphone a bit more up. To give you now an update from the other side of the Atlantic regarding compliance. And you all know that the compliance, the healthcare compliance regime in the European Union among all the European countries is not harmonized. So you can guess there's a lot of new things are ongoing, very country-specific things. But I know from a lot of discussions with our clients and with other members, stakeholders of the community, that in particularly two exceptions concerning the general prohibition to grant benefits and benefits in kinds to healthcare professionals of great interest. That is the meal limit or providing meals and what the meal limit in all countries are. And also the gifts of minor value. We have interesting developments, not only in Germany, but also in other key life science markets like the UK and France, and very happy to give you an update there. And then a very dear client here from the Bay Area advised me that there is also great interest in an enforcement update on the advertisement side. And I'm therefore very happy to conclude my 15 minutes overview on the compliance update from the other side of the Atlantic with that topic. Very briefly, to give you a bit of understanding about the legal background for the general prohibition to grant benefits to healthcare professional. As I said, this is not harmonized standard, although you find in the MITEC Europe Code of Ethical Business Practice in the self-regulatory industry guidelines on EU level, you find some language that it is prohibited to grant benefits to healthcare professionals. And you also find this in the pharmaceutical regime in the Directive 2001/83. And the national legislators have taken the occasion to include this also into their national law. You might be aware that this is certainly included in the UK Bribery Act, but also in the German Act on Advertisement of Healthcare Products, and also in the French Anti-Kickback Statute. There are exemptions that apply, and when you have a look at the regime that, or the rules, the regulations that I just mentioned, you see that there are always exceptions, and from the practical standpoint, most relevant is the one that is items of minor value. So the language is always around inexpensive items or gifts of minor value. You find this first in the European Code of Conduct, MITEC, Europe Code of Ethical Business Practice, in the Directive 2001/83, but also in the German Act on Advertisement for Healthcare Products. We have reached out to our colleagues in other member states, and all of them have confirmed that this exception also applies in the member states that you are seeing here. So you can be very sure that, sorry, I'm not clicking the slides. Is that helping? No, we are. Here we go, here we are. Thank you very much. So they have all confirmed that the exception providing gifts of minor value also exists in other member states. Now, very quickly on the news in Germany, to first give you some background. Since 2008, we had an applicable threshold of €5. that was initiated by the pharmaceutical industry guideline, by the FSR Code of Conduct. The board of directors have issued a statement, I believe that was in 2008, saying that an inexpensive item is something that is below the threshold of €5. That was very quickly withdrawn after the German Act against corruption in the healthcare sector entered into force. That was in May 2016. And in parallel, also some established case law appeared in Germany saying that the value has to be set by €1. So that's more or less nothing. But this legislation only appeared in relation to product-related advertisement with pharmaceuticals and addressed to healthcare professionals. So there was always a discussion among the legal commentators. What about product-related advertisement or benefits provided in relation to members of the general public, to laypersons, to patients, and in context of product-related advertisement for medical devices? So not surprisingly, the regional court in Hamburg took the occasion last year to say that the threshold now has to be set by €5. It was very well reasoned in our view, because they have said the inflation and the price increase, in particular during the COVID time, was so significant that you cannot impress someone anymore with something that is above €1. So you have to set it at €5. And in addition to that, you also it is also allowed to have price competition for medical devices, which is not the case for RX medicinal products. So that was the reason for the regional court in Hamburg to say, no, we have to set up the threshold now to €5. But unfortunately and surprisingly for us, the higher federal court in just July this year rejected this case law and has again said that the abstract risk of undue influence of the therapeutical decision of a healthcare professional can only be excluded if you provide items that are below €1. So this is the newest development in Germany concerning the gifts of minor value. We certainly reached out to our colleagues in other member states to see how the threshold is in other countries, in other member states. You see the country overview here. We have quite a bit of diversity, as you can see. For instance, Belgium and the Netherlands are leading, and they are saying gifts of minor value are those below €50. Then Germany, as said, €1, Spain, €12, and France, usually the strictest country or the most complicated country when it comes to interaction with healthcare professionals. They even go up to 20 to €30, depending on the item that you provide. Interesting in the UK, currently for the medical device industry, expressly written in the industry guidelines of ABPI is still £6, 6 British pounds, but we would expect that this will be updated very soon, because we already see in the ABPI Code of Conduct, which is the Code of Conduct for the pharmaceutical industry, threshold of 15 British pound, and also the NHS guidelines refer to that. So we would expect that the next amendment or modification of the ABPI code, this will also be extended to €15. Then the second exemption for providing to the prohibition to provide benefits in kinds is meals. These are still allowed in certain contexts. So when you have a consultancy agreement with a healthcare professional, if you provide an educational grant, also in the context of internal trainings, events, and business meals, it is still allowed to invite healthcare professionals. And the question is what the meal limit is in that respect. And there was just recently, in terms of 2 years ago, an update in Germany from 60 to €75. We had for the time from 2008 again until 2023, May, an applicable meal limit of 60 euros. This has now been extended to 75 euros. And you see that we have less diversity here. Very interesting. We have just new developments in France, as I understand. The meal limit for physicians has been set up. If you invite a physician in a high price country, up to 100 euros. If you invite a physician in one of the major cities in France, you can go up to 90 euros. And when it's on the countryside on 85 euros, you have to take into account this applies only to physicians because the CNOM is setting this. Also the professional body for physician has set these new guidelines. And the LEM, so the pharmaceutical industry, is still adhering to 70 euros. So have in mind for if you're a pharmaceutical company and you invite a pharmacist or a physician, it's still 70 euros. If you're a medtech company and you invite a physician, then it's up to 100 euros. Interesting question, of course, when you carry out an internal training event on an international basis. What do? You invite someone from Belgium. The event is taking place in France, and also physicians from Germany and Spain are coming. And the only guidance that we are finding here is at medtech Europe saying you have to adhere to the standards of the country where the event is taking place and also take due consideration of the meal limits applying where the physician are having their practice. So I see that I still have 3 minutes. I'm now coming to the enforcement update. You are aware the MDR is applicable since May 2021. We are now in a comfortable position that we at least partly have a harmonized standard in relation to product-related advertisement for medical devices among the European Union. This is Article 7. It has 4 subsections to deal with misleading advertisement. One is expressly prohibiting off-label advertisement, not very surprisingly for you here in the US. And the last one is now implementing to companies when they carry out a promotional activity that they have to include the mandatory information, so the safety-related risk information into that advertisement. I said we have only partly harmonization because the Article 7 still leaves room for prohibiting direct-to-consumer advertisement, and some member states have taken the occasion to implement that in their law. When it comes to product-related advertisement for medical devices of a high-risk class and those that are reimbursed under the National Health Insurance Scheme. Just have in mind, Germany and UK still don't have it. So direct-to-consumer advertisement is still allowed in these countries. Makes it quite difficult if you run an EU-wide website, but have in mind, some countries it is prohibited and in some countries it's not. An enforcement update for Germany. For years, we had very strict requirements when it comes to the advertisement of healthcare products like medicinal products and medical devices. The higher civil court has always said that we need very strict requirements. If you do a safety and efficacy related product claim, it always must be based on sufficient scientific evidence, and sufficient scientific evidence means that you have to comply with gold standard clinical trials. So whenever you do that, it must be based on a randomized clinical trial. And we were hoping that this established case law in Germany would find an end under Article 7, but unfortunately the regional court in Düsseldorf, just 2 years after the implementation of the MDR, confirmed that this gold standard requirements apply also to medical devices. Maybe to relieve you a bit from the pressure that you now feel from the established case law in Germany, Germany, as in also in other member states, as I have learned from my colleagues, is self-regulatory. That means that you might not, in many cases, experience enforcement action from public prosecutors or competent authorities. It's rather self-regulatory, so the competitors are reviewing the marketing practice of your company. And if you are in the gray area or you even exceeding the gray area and you do misleading advertisement, then the risk might be high that you receive a warning letter, a cease and desist letter, and that you would end up in a preliminary injunction in Germany. But again, this is less strict than when the prosecutor is ringing at your door. So this is something that you can take into consideration. If you lose the case, if you lose the lawsuit, you need to reimburse, first of all, cease and desist from this marketing practice, of course, but you also need to reimburse the legal costs of your competitor, which is, depending on the value of the case, usually around 5,000 to 10,000 euros. So that was my very brief run through the healthcare compliance update from the other side of the Atlantic. And I'm very happy to hear if you have any questions. And I say thank you very much. And Mark, please remind me, now we have a refreshment break and we are coming back in 10 to 50 minutes. Thank you very much.
All right, welcome back, everyone. Hopefully you had a good break, or if you're at home, you had a chance to step away, get a snack or some coffee. But we're going to dive in for a brief but very rapid update on privacy, both in the US, and then Oliver will jump in on the EU perspective of that as well. What I want to share mostly today is about some of the enforcement trends we're seeing on privacy. Some of them will be things you're familiar with, and some may be some newer areas of risk that many companies are experiencing right now. So just a few trends here that I'll focus on, and this is a highlight slide. I think we'll get into a little more detail on some of these as we go through. But I want to share this just to give a sense that there is active enforcement in the US right now, both from a HIPAA enforcement standpoint. As usual, that tends to focus more on the security and cybersecurity side of things. So you can see a few different settlements related to that with HHS at the forefront. And then some sort of a newer thing that we're seeing is continuation of the False Claims Act cybersecurity enforcement. So you'll see a reference there. And then we can't ignore, and some of this, a good part of this presentation is focused on online tracking technologies and how US enforcement has been ramping up and focused on that area. So we have a few different examples of those cases as well. Just a hodgepodge of laws here. I mainly want to include these so you can take a look and have a sense of what we're talking about. There is a lot of legislation at the national level, and then, of course, at the state level that address privacy. So if you're concerned about privacy, there are a number of different areas that can draw your focus and attention, and they're highlighted here. So one of the laws that we're seeing some enforcement activity around is the California Consumer Privacy Act, as amended by the CPRA, or Privacy Rights Act. What we're seeing with this in particular is a focus on this concept of sold or shared, which is a key element when it comes to online tracking technologies of this law. So we'll talk a little bit about what that means, but essentially if you have a website or some other way that you're collecting consumer information and then sharing that with a third party, either in exchange for financial remuneration or other kind of in-kind consideration, or if you're sharing it for particular purposes, which we'll get into, you could be implicating this law. So some key terms, and these definitions do not come from Black's Law Dictionary, but we're talking definitions. So sold, of course, is about exchanging for monetary or other consideration. So exchanging personal information will subject you to the requirements of the statute, which include offering an opt-out right, fully disclosing what exactly that disclosure involves and what the purpose of that disclosure is. And then shared, this is where things get very interesting, is about exchanging or providing access to personal information to a third party, and for the purpose of what we'll call cross-context behavioral advertising. These are some big terms. What I'll say simply is, if you have a website that is providing, or an application that's providing information to third parties through cookies, through pixels, through other technologies that can access and withdraw personal information about consumers, and then build that into a profile to target marketing to those consumers, it essentially is going to fall under this law and this definition. So that covers a lot of ad tech. So if you're actively marketing to consumers or to other individuals, probably this is happening on your websites. Of course, California is not the only state doing this in their legislation. Colorado has a very similar approach to this same topic, slightly different language, but a similar kind of approach. And again, opt-out rights are a significant part of this, and full disclosure of those activities. Texas, following suit, has also established its own opt-out program very similar to Colorado, again using similar definitions. These are some examples. Several state laws have almost identical or very similar concepts with some variations, but these concepts are really clear across many of these state consumer privacy laws. So enforcement, this is, of course, maybe where we're most interested is, yes, these laws exist, but what's happening, who is experiencing enforcement and why. So one recent case that I think is illuminative for us in the healthcare industry especially is Healthline. So healthline.com is essentially a website that produces lots and lots of articles that respond to typical consumer questions. You might go to the website to look up, if I have this diagnosis, what can I expect, or what kind of indicators are there of this diagnosis. So this website, of course, monetizes advertising. So there's a lot of different ad tech tracking and so on that's on the website. When you visit the website, data is then shared about your visit with these ad tech companies. And that's how essentially the revenue of this website generates revenue. Well, one thing that's interesting in this particular case is that they did have an opt-out banner. They had the kind of cookie consent banner that you would typically see, and it ostensibly was working, but in fact, it wasn't actually turning off all of the cookies, allegedly at least, while they were using that website. Despite the consumer's opt-out, it was still sharing. So the AG in California said, well, this is, of course, not accurate. It's not compliant with the law. And so we see some settlements. One of the focal points of this is that, and I think interesting for healthcare in particular, is that article titles were identified as potentially health information. So along with some of your typical cookies and other data that's shared, article titles, other tags that were connected to the website usage by individuals may have revealed health information to these third-party ad tech companies, and therefore it kind of heightens the concern that the AG had around this particular activity. So keep that in mind. Potentially we may see more of that, kind of this inference of health information being treated as health data, which could implicate a variety of other laws that we see, say in Washington with the consumer health data law there, and a couple of other states. So you'll see here some of the titles, for example, were the ultimate guide to MS for the newly diagnosed. You can see how if someone visits that webpage, there could be a strong inference that they may have MS or a loved one does. In the interest of time, I'm going to keep moving here. So BetterHelp, this has been a case for a couple of years that we've referenced, but just again, healthcare and data sharing through websites is a focus of enforcement, both for states like California, but also for the FTC. And so again, a focus here was ad tech embedded in a website designed to present health services or healthcare services to individuals. And so you'll see here one of the ways that the FTC really likes to enforce their privacy. Essentially, there's no privacy regulation that the FTC directly enforces, but they look at either false or misleading claims. So things like, we will keep your information private, we will always, keep your information secure, and then compare that to the activity. So there may be false or misleading claims that lead to enforcement there, or potentially unfair practices. So if they believe that consent should have been obtained for a certain kind of sharing, particularly around health data, they may look at that and say, yes, you may have disclosed that sharing, but you didn't get consent. So there has to be some level of additional support for sharing when it comes to health information in particular. Again, another healthcare case. Monument is a healthcare provider that provides addiction counseling services. And again, there was some concern around how is information being shared when a consumer uses their website, and particularly when they're receiving these very sensitive services. And so the focus here again was certain kinds of events that might trigger while you're using the website to support analytics and tracking. So let's say you scheduled an appointment, some of that information would be shared with third-party ad tech providers. And so therefore, that could create disclosures of sensitive and even detailed health information about individual users of the service. So you'll see here, again, this idea of custom events, which you'll see if you're kind of digging into, say, what is marketing doing with our website? You'll start to see some of these titles or things that might relate to particular healthcare activities or forms that are being completed, surveys on your websites, especially when it comes to direct consumer activity that could implicate these requirements. Now, more on the HIPAA side, we're still seeing continued enforcement when it comes to HIPAA compliance. You know, if you're in the device or med tech space, you typically will see, you know, maybe a business associate agreement here and there. You may even have a company that is a business associate. Some are covered entities if they fall within those definitions. But regardless, one of the focal points here is often on security risk assessment. So that's any electronic PHI or protected health information within the environment needs to have an inventory to gather what is there, and then additionally an assessment to evaluate, does this storage, maintenance, use of this data adhere to the security rule requirements? Finally, another note on the FTC, and I'll just briefly mention this one, but again, recently a focal point of FTC's enforcement is sharing health data with these advertising organizations. As kind of a final note, I want to touch on another area of risk that we're seeing, and this is not a regulatory concern necessarily, although it's tied into that, but we're seeing unique and kind of creative plaintiff approaches to seeking compensation. So one way that we see that is through laws like the California Invasion of Privacy Act or various other state laws that offer essentially like a wiretapping or kind of invasion of privacy, as you typically would think of it, to approach website usage. So that can occur potentially through sharing with third parties at the contemporaneous moment that they access your website, information about them. That can be one way that these cases are brought. Again, that there's some debate and still some challenges in the courts to even get these through summary judgment and so forth, but some of them are moving forward. This one in particular, though, is unique in that normally when you're under these state privacy laws, they typically don't offer private rights of action. However, within California, there is an exception for data breaches. So if you have a kind of a traditional data breach, individual plaintiffs can bring actions in essentially saying, look, my data was disclosed in an unauthorized manner, therefore I can bring a private right of action through this exception. Here, someone took an example of one of these online tracking technology disclosures and said, that's a data breach. And so brought an action on that basis, and it passed summary judgment. So there is a potential for more of this kind of activity, which is unique in the sense that typically you're looking at regulator enforcement from the Attorney General or other government bodies. And in this case, that could open a door to more private rights of action to address what we typically see as only really a regulatory enforcement activity. So I'll close there. I think I'm at time, unless I have any quick questions here.
Question online. If a California company has a patient education website with cookies on by default, as long as the company truly honors an opt-out request, is there any issue with having cookies on by default, given the Healthline Media complaint? Yeah,
that's a great question. So there are avenues to share and or sell data lawfully. You do need to disclose that clearly in the privacy policy, privacy notice. You need to offer an opt-out right that's conspicuous. So it needs to be something that's visible to the consumer. They need to be able to do that easily and through both forms or through what are called these universal opt-out mechanisms or GPC, global privacy control signals. So if you have all of the proper trappings around that, you can lawfully do that. What we do see though is it's difficult sometimes to set those up in a way that's maintains, consistent and functions properly. So we typically are seeing companies set that up initially and then having to recheck, is the cookie policy, is the cookie consent management still working, months later and years later. So that's a key part of that. All right, thank you. I'll turn it over to Oliver.
Good. So we are moving to a completely different topic, actually. Before I start, so we are moving away now from any privacy and personal information related topic. I will speak about the European Data Act, which is, so to say, the latest piece of legislation in Europe with regard to digital and data regulation. Can I ask who has heard about this piece of legislation, the EU Data Act? Okay, well, about a half of you. It's very challenging to speak about the Data Act in 15 minutes because it's a very complex piece of legislation. As I said, we are not speaking about personal information. The GDPR, as we all know, is dealing with personal data. The Data Act has a totally different direction. It's dealing with product data, with product-generated data by IoT devices in a broader sense. And the goal of the European Commission by launching the Data Act actually is to create a fair, competitive and innovative data economy in Europe and to break up data silos that are caused by certain manufacturers because they are, well, the holders of data. And this needs to be broken up according to the European Commission and make data available all over the country. So many principles that you see here have already been discussed when we earlier spoke about the Artificial Intelligence Act. Like many other European regulations, we have a very broad scope of this act, and we have the local the market location principle that applies. So again, similar to the Artificial Intelligence Act, as soon as you are launching a product that falls under the scope of this act on the European market, the regulation applies. So the decisive factor is the placing on the market of the product or providing a related service to this product in Europe, and the registered office of the company is irrelevant. And as you can see here, and that's actually the challenge that we already addressed earlier, there is a lot of overlap between AI Act, between the GDPR, and between the Data Act. And that's really what is the challenge here. And as a medical device manufacturer, you have to comply on top with medical device regulation in Europe and other principles. So it becomes more and more challenging, in particular for any medical device manufacturer that is operating with digital technologies, IoT-based connected devices. That's really becoming tricky. So to make it very brief, what does the Data Act apply to? It's important to understand that any connected product that obtains, generates, or collects data concerning its use or its environments is covered as long as it's able to communicate. And it doesn't matter which technical ways the product uses to communicate. So medical devices, vehicles, game consoles, smart home devices, any kind of connected products are covered. And for connected medical devices, this plays a particular role. So the product side is one thing that is regulated, and as soon as a product has a related service to this product, that might be covered as well. To give you an example, a hearing aid that is combined with an app on your iPhone where you can adjust, then both would be covered, the product itself plus the related service. And then we have actually three groups of addressees of the Data Act. One is the data holder, that is the natural or legal person that has the right to use and make data available. That can be the medical device manufacturer, as long as you, for example, have rented or leased a medical device and you are using the data that is generated, for example, by a hospital that has this product in use. to carry out maintenance services, or what we all know many companies do, to further technically improve a certain medical device, a certain technical product based on the data that are generated by the use of data. So that provides a lot of insight and information, not only about the product is used, but also how you can further innovate and develop further a certain product. Then you have the user that again can be a natural person, or it can also be a business that buys, rents, or leases a connected product. And then finally, a potential data recipient, because there are scenarios where a data holder would be obliged to provide access of the data that are generated by this product to certain third parties. That could be potential data recipients, just to give you a very brief overview about the addressee. And what you see here is a completely new set of data definitions under the Data Act. Again, important to understand, we're not speaking about personal information, so we're not speaking about health data or anything else, but product-related data. I will not go into the details here, but as you can see here, it's a very technical description of different data categories that are addressed by the Data Act. So who does the Data Act apply to? From a medical device manufacturer perspective, there are two key roles. It might be the case that you are a data holder. That, as I said, is the case as soon as you are able to control the data that are generated by another party, for example, a patient or a hospital, by using a certain medical device. It can also be that you're not a data holder, but you're still the medical device manufacturer. As soon as the product is able to produce data, there are still obligations also for the data for medical device manufacturer who is not a data holder. You still have transparency obligations. You have the obligation to potentially provide access to this data. There needs to be a technical way to access the data that are generated by the product. And then, as you can see from this graph here, if you are considered a data holder, you have to enter into a contract if you want to further control the data that are used and that are generated by a third party, by the user, for example. And that is one of the important parts here. So the spotlight that I want to briefly present today is how can you, under the Data Act, use product data yourself as a data holder, as a data manufacturer, because it's very important for the further development and innovation of certain products. What Article 4 of the Data Act explicitly state is that a data holder shall only use readily available data, non-personal, as I said, on the basis of the contract, which means you have to enter into a contract in the future if you want to use data that are generated by a user. That's a very important change that we see here. I will skip this here because that goes more into the details about what has to be regulated by a contract. And let me skip this as well, but the important part is here. To whom do I have to make product data available? That relates to the right to data access. You might recall from the GDPR, where we have a privacy by design principle, which in other words means that there is a technical obligation to design a certain product in a way that considers privacy principle. What we have with the Data Act is an access by design principles. That means in the future, a product needs to be developed in a technical way that enables the data user or third parties to access the data that are generated by the product. That can be an interface, it can be a platform that can be accessed in order to make use of this data, but that is one of the very important key obligations. To whom do you have to disclose these product data? I referred to that already briefly. The data must be made available to a third party at the request of a user. and the data holder and the data recipient must enter into fair, reasonable, non-discriminatory and transparent agreement about the use of this data. The so-called FRAND clauses do apply here, which again means that for many companies that fall under the scope of this act, you will need to adjust and update the contract that you currently use for medical devices as long as they fall under the scope of the Data Act. So that's it in a very, very tiny nutshell, actually. There were only 15 minutes today to briefly inform you about that. As you saw from the slides, the Data Act already applies. It applies since September 12th this year. I can tell you that none of our clients has been able to be fully compliant by this date. So if you should be surprised now, you're not the only one. But I can also tell you that it's quite challenging depending on the number of medical devices that a company has under this regulation. And with regard to further steps you should take, an internal assessment is the very first important step here. And yeah, we try to help our clients with a Data Act toolkit that we created. If you're interested in that, I'm happy to share a slide deck, a separate slide deck about that. But yeah, there are already questions. So looking at the time, I'm happy to take the questions. Are they from the remote audience or? Okay, good. Then I'm very much on time. Thanks for. Thank you.
Good morning, good afternoon. My name is Nate Downing, as you saw me before in the panel this morning. I'm going to be giving an update on US regulatory, focus on the FDA, and then Cord is going to take over and give an EU regulatory update. So, you've seen me before, so I'll skip this. So, charting a path forward, some topics that I want to hit on. I've got 15 minutes, which is plenty to bring up the things that are important, but it would take hours to really deep dive into everything going on right now. And so I want to discuss FDA during the shutdown. It's obviously, the shutdown continues. When I started thinking about this presentation, I didn't know if the shutdown would still be going on at this time. So I kind of had this as a contingent. Will it be going? Will it not? But as it drags on, there are more impacts, more implications for the regulated industry, for what FDA is able to do. So as time goes on, this topic becomes even more important. So it was certainly, will I discuss it or could it be the entire conversation? I'll get into some recent FDA activity. There's been some letters issued, some other things that have been taken place that are important to keep in mind that kind of give you an idea of where FDA is at, how FDA is approaching things right now. Looking ahead, I'll kind of talk about some things that FDA has put out about what they're going to be doing, some guidance documents, other things that they're going to be focusing on, which I think is always important to keep in mind, be ready for what's coming, and then navigating the future, some ideas that I have on how to find some certainty amidst a lot of uncertainty. This is also great if anyone in here has an opinion or has an experience that relates to what I'm talking about, feel free to raise your hand or online, because ultimately right now, FDA and navigation of FDA is gathering a bunch of data points, right? As many little data points as we can get. What was your experience with this division or that division, and how did you get through a pre-sub or an IDE, or if you already had something submitted, how is that review going, right? The more data we capture, the more we can all prepare. So government shutdown, some high level, FDA considerations. The first one is funding, right? I think you'll see different publications have different estimates on how long the funding would last from the user fees they'd already captured, right? Is it 3 weeks? Is it 6 weeks? Is it more? And so we're kind of getting to that point, right? As Amanda said, I think it will be day 36 now. And so we're getting to that 6 to 7 week mark. And so maybe we'll start to see more impacts. Are we going to see less capability at FDA, even for those who had already submitted something? It's under review, right? Your user fee's paid for, so legally you're allowed to be reviewed, but if no one's there to review it, the impacts are obviously great. So understanding that, are we going to see less focus on other areas, right? Right now, I've heard that individuals have been pulled off of some, I'm not going to call them secondary, but non-review functions to try to review. Well, I had a client who encountered a reviewer like that, and that was really difficult because that reviewer, technically still a reviewer, didn't have the experience. And so there was a lot of difficulties in getting up to speed. You have to reorient the FDA on your product. It takes a lot of time and energy. And so as those impacts occur, you have to keep being nimble and thinking, who should I be bringing to a meeting with FDA? Can I find ways to reach out to FDA and let them know more about my product or more about what's coming next? And so some really high-level FDA considerations that could have major impact on all of industry. And then quickly, CDRH, what are the impacts on current work, right? If you have a submission that requires a user fee right now, even if you paid it earlier because of the FY switch, you can't get it into FDA. So as a business, every month matters, right? When you have an RTR change, for example, you want to get that in front of FDA because you want to know that in 120 days or 90 days, if you really have no questions, you're going to be able to implement this change. You think about the parts you have on hand, how many labels you've printed, how many manuals you've printed. All of those things are planned months in advance to try to be as smooth as possible, limit resource burn, resource waste. And it's really hard to give you a good prognosis of when you can continue that again. So that's an impact. Pending submissions, right? IDE, some of these things that are pre-submissions, they don't take a user fee. But if there is not the capability, you might get a submission in and that feels great, but you don't know what kind of review you're going to get, if at all, right? I have seen sometimes where I've had questions from FDA that I wouldn't expect typically if I felt like they had more time to review. So I'm getting a spin, if you will, when I would not have in the past. And those are impacts that aren't directly tied to anything from a regulation, or I can point to and say, this is why this happened, but that's the reality of resource limitations. CEDAR, NDAs under review. I had a client who did get an NDA approval a few weeks ago, but since then I've heard that those NDA reviews are even slowing down. So if you've got a new drug application that was already in, right, you are pretty specific on your dates to try to launch a product, and if those are being slowed, that can be impactful as well. Obviously, future submissions. This is just a very broad issue. Future submissions that require payment are what spur innovation, what spur new products to patients, what spur innovation because you're able to recoup the money that you invested in those, and that's a big hit. Also, I think about investors, right? When the FDA isn't doing what we expect them to do, how can you go to your investor and give a timeline and say, hey, we need these monies, but I've got a plan that in, due to a de novo, right? I've got a submission in, I'm going to do a de novo, 120 days, 180 days, I'm going to get something to market. Well, how do you give that confidence right now if you don't even know when the government will be open? So I'm giving you issues now. We'll talk about solutions later. They're not perfect solutions, but some ways to navigate it. And so we're going to talk about how to mitigate these industry disruptions. And I would just say kind of up front, being mindful of them is the first point, right? That's why I have this slide. You need to be mindful of what's going on. You need to read news. You need to be aware of your industry associations. And the more you can converse with each other, that's why I said, if you have an experience that's helpful to the people in this room or the people online, share it, because it's a world where we can all help each other. So some recent FDA activity. First off, I'm going to talk about ad promo and the letters that were issued on DTC advertising. It's really interesting to see so many letters go out. Every company with an NDA basically got a letter saying, hey, we're concerned you're not in compliance with risk. We're concerned about adequate provision, which also, lines up with the HHS communications of, hey, we think there needs to be more risk in the pharmaceutical products. I would say medical device, not far behind, right? If you think about the resources that goes into the oversight of communications of drug promotional material, obviously there's a lot more capability to get letters out, to kind of copy and paste whatever name you want to put in and send that letter out. But that's something that companies should be aware of, right? FDA is clearly letting you know that risk is part of their current thought process, the current algorithm on whether you have fair and balanced material or not. And so some of the conversations where it's been, well, that company left this off, right? I've been kind of going back and saying, yeah, they may have, but they may get a letter, right? FDA has also stated they're going to use AI more, which is something we'll touch later. And that's very easy for AI to say, hey, look for good things that have been said, look for bad things that have said, right? That's an algorithm that can be instituted and pretty easily utilized to then get in front of somebody, a real person maybe, to then say, oh, I'm going to write a letter to this company because of what I just saw. So being cautious with your, not just DTC advertising, but also your professional advertising, understanding the rationale for why you want to put safety information, why you want to balance things. It helps patients know what's coming. It helps HCPs. And it also helps avoid FDA scrutiny. Product review impacts. I know I touched on that before. It's just because even before the government shutdown, right, there was still some impacts because there were layoffs. Some were hired back. Some didn't get brought back. I've been in a pre-submission for an IDE where the main scientist, I'll say, who understood the technology, who understood the science, was no longer there. So as a company, I had to help them take a different approach of, hey, let's bring a new expert on board to make sure that we can get back into the basic science. Let's educate and then get back to the topics that we want to discuss, right? So understanding some of the shortcomings with resource limitations at FDA allow you to be more impactful when you are in front of FDA. Inspections are still ongoing. There's certain focus on sometimes more of a foreign focus, but certainly FDA, their charge during government shutdown is still patient safety, which is directly tied to inspections. So it's not like government shutdown, they're not going to be coming to my door, right? Remain ready, keep your quality systems up to date, continue to do those things that you already are doing, but don't, feel a little bit false sense of security because the government's been shut down. And then some other initiatives that, FDA has been looking at. And I think some of these initiatives are across the board, high level. Sometimes it's working with industry, sometimes it's trying to move faster in a topic. There's a lot of working groups going on right now, and I'll get more onto the other initiatives in the next slide, but really being aware of not just what FDA has done, but what kind of information are they putting out there for what they're going to be focusing on in the future. All right, so like I said, now we're at the other initiatives. Looking ahead, this is just interesting. The Digital Health Advisory Committee meets today, right? That's an important meeting for a lot of industry who are putting out products that are digital health products, right? And so that advisory committee, who knows how long rulemaking will take right now to put out a new guidance document, but when you see the output of that meeting, you get nuggets from it, right? You understand what FDA might focus on. You understand how to tailor submissions, tailor development, tailor all those things to, at least if FDA doesn't have a guidance document, you can say, hey, I'm up to date. I saw in this meeting, FDA, you stated this. That's why I did it. It gives you an argument when you're in front of FDA if you don't have something to guide you in your decision making. Proposed guidance for FY26. We're already in FY26, so some have actually been released, but I always think it's interesting to know what might be coming in FDA when they give their alert. They give an A list and a B list. And so I have a couple of guidance documents that I think are interesting. This could be a final guidance document that's expected. It's real world evidence to support decision making for med device. Right? A lot of fanfare happened around this a couple, 2, 3, 4 years ago. I haven't seen great movement on it. Right? It's really helpful for medical device companies to understand how they can use real world evidence. And so maybe there'll be more clarity and there at least more of a conversation that you can go to with FDA and start to plan some future product development around the availability of real world evidence. Finalization of the predetermined change control plan, right? That's a really important thing, especially on the topic that we've been focusing on today with artificial intelligence. The amount of changes that can occur in a medical device product are great, right? So if you can get in front of FDA and maybe there's going to be more clarity in that document and utilize it to have more predictability for your marketing team, for your regulatory team, for your engineering team. And then a couple others in the B list, some more things on AI-enabled device software functions, human factors in the medical device space, right? Things that can really make a team, bogged down sometimes when you're trying to figure out how much human factor testing is enough. And then you go to FDA and, they say, hey, there's more needed. So could be a pending draft guidance on that. Final content to be seen, but at least some interesting information. So how do you navigate FDA right now, right? It's really different than it's been in the past, even a year ago. And that's, it is what it is. So that the goal of industry is, I can't really change that, but I can be smarter on how I approach it. I can approach it differently. So the first one is mindful planning, right? The things that we've talked about today, the things you hear about. If you know there's delays, let your business know there's delays or there could be delays. If you're not sure when your timing might be, if you have a relationship, utilize it. Do a 5-minute call, send an email, try to reach out. And also at the same time, mindful planning goes to the FDA as well. Hey, I have an RTR coming in 2 months, FDA, just so you know. They don't need to see any official document. They're not giving you approval that your RTR is going to be accepted, but they're going to start resource planning and allocate. And they're going to say, hey, in 2 months, we need to have a reviewer ready to take this RTR on. And maybe you've given yourself a little bit ability to get put on top of that pile. Pre-submissions, other touch points, right? Certain types of submissions we all know can't be accepted right now, but others can be. So think about, is there an item, is there something pending in a submission you're going to submit that you need to burn down risk on? Well, maybe take advantage of the shutdown right now and get a pre-submission out there and focus on that singular item. So when you move to your submission, you've got more clarity and more certainty on what the outcome might be. Industry working groups, I stress this a lot, and I've said it like 3 times here already today. Work amongst each other, work with your industry groups, figure out what experiences you've had, because the more you do, the more you gain and the more predictability you have. And we all know our businesses like us a lot more when we're predictable. Even if we're 2 months later, but we are actually on time when we said it might occur, the business can live with that. So that's something that's really important to be mindful of. Partnership. I think it's important to partner with FDA, right? I also will talk in a minute about being ready to have an appeal if you need to, but also partnering with FDA, offering to lessen their load. Hey, I just sent you a 40-page thing. Let me hop on a call and explain to you what it's about. Let me give you a reduction of it. So then when you're starting to read it, you've got the basic elements of it down and you've saved yourself maybe an hour, FDA. And sometimes I've seen FDA take me up on that offer many times, actually. And so continuing to be that partner and let FDA know that we have the same goal. We want to get this safe and effective product to market and help patients. So, my last couple of minutes, there are issues. Let's be real. There just are issues at FDA. There's, if you're traveling, you've seen that there could be issues with flying in the next couple of days, right? As they reduce flights. That's a reality, but being aware of those is way more important than sticking our head in the sand. So addressing those head on, putting those into your project plan, into your timelines, into your resource requirements, really important. Mitigation is possible. Not 100%, I can't get an RTR in front of the FDA right now, but I can start to say, well, let's do other things to make that RTR go smooth when I am able to submit. And finally, I want to close with being ready to assert your rights. So what I mean there is, notwithstanding the shutdown, but if you are seeing FDA making decisions based on resource constraints, you don't have to roll over and say, oh, okay, well, we'll come back, right? Think about what it means to appeal, making sure you're clear in your communications that you did ask FDA and they did respond to the specific issue. So then when I go through an appeal, right, it can start with a regulatory appeal, but you may even get to an Article 3 court. I've got it really clearly laid out why I'm appealing, why FDA erred in their decision-making, and what my basis is for appealing. And when you do that thoughtfully, you hope not that you don't have to do it, but if you do, now you've laid a path forward for appealing an issue, making sure that you don't get harmed based on FDA's inability to meet a request or to have the resourcing to pay attention to something. So I like to close with that. Assert your rights. I had partnership on the last slide, and I really mean it, but also be ready to say, hey, FDA, you're wrong. That's not fair. I'm not mad, it's not personal, but this is my business. Patients deserve this product. I am ready to appeal and exhaust my remedies if necessary. So I don't know if there's any questions. I got like 30 seconds. I'm happy to take a question or two. Otherwise, I'll pass it to Cord. All right, thank you.
So Nathan, thank you very much for the update from the US regulatory side. We are now going back to the other side of the Atlantic, a regulatory update from the European Union. And you can guess a lot is going on. And I can confirm that a lot went on in the last months and also in the last year. But having in mind today's focus on artificial intelligence, I'm very happy to start with some background on the regulatory side for digital health applications. Some stakeholders in Europe currently say there is a momentum for these digital health applications for medical apps that is triggered certainly by financial incentives, but then also seeing on the regulatory side that there is very strong headwind coming up. But very happy to discuss this with you. Then brief overview of the other regulatory, the remaining important regulatory updates. We have notification requirements for manufacturers since January this year. If you anticipate that there might be at least a temporary interruption of your supply into one member state or the entire European Union, you're now required to report this not only to the competent authority, also to other members, economic operators in your supply chain. This is something that manufacturers are now required to do. This is mandatory. Then there is an urgent call by the European Parliament since last year of a revision of the MDR and IVDR. And also ODAMED. You might be aware of ODAMED. This is the European medical device database, which already runs for a couple of months or even years. And the notification or the reporting of the economic operators in the supply chain is currently still happening on a voluntary basis. And the listing and the reporting of all economic operators becomes effective from January 2026 on. So be aware of that. Also very interesting, we have a fully harmonized regulatory framework in Europe by the MDR, you all know this, but we are now also approaching that the EU, the European Joint Health Technology Assessments might become also harmonized, and we are now starting, in Germany it's now starting, not in Germany, in the European Union, it's starting that there are been set up on an EU level. And for specific medical devices, you will see that there is a joint health technology assessment for medical devices class 2B and class 3. So these risk class are concerned. And also if their conformity assessment procedure involves a scientific expert opinion, then you might see in the future that we have this joint HTA procedures on an EU level. And then finally, quite interesting from a practical standpoint is the allowance and the extended opportunities to use electronic instructions for use for your medical devices. So, but let's start with the digital health applications and the statements, the quote from some stakeholders, they are saying that there's currently a momentum in Europe for these medical apps, and this is certainly financially triggered because in Germany, the German Digitale Versorgungsgesetz has been implemented in 2019, and the consequence was that since 2021, these medical apps, if they fulfill certain requirements, they are getting reimbursed under the statutory health insurance system, which is quite favorable because this covers 85% of the citizens in Germany. So this is very favorable. And if you have a medical device, which is software, which can provide medical benefit, which fulfills certain data security requirements, and then is also has a CE mark and is listed in the so-called BfArM DiGA registry, then it is subject to reimbursement in the statutory health insurance system in Germany. And I looked it up just yesterday. I can see that 73 of these DiGAs are currently listed in the BfArM registry. So this is a clear economic tailwinds that we are seeing for this digital health applications. And this also happens in France since a year. We have these DMDs, digital medical devices, and they're also reimbursable under the French National Health Insurance Scheme. And something similar is coming up in Belgium. So you see that the manufacturers and suppliers of digital health applications currently experience a clear tailwind for their solutions from an economic perspective. But when we have a look at the regulatory side of things, you will see that a little or a very minor change that has been introduced by the MDR to the classification rules puts the entire industry for digital health application quite under pressure, because you see I've quoted the relevant wording of the Annex 8, Chapter 3, Rule 11. You can see that software intended to provide information, which is used to take decisions with diagnosis or therapeutic purposes, is to be classified as software as medical device class 2A, at least class 2A. And most of you might know when a medical device, software as medical device, is classified as 2A, then the conformity assessment procedure under the MDR requires the mandatory involvement of a notified body. And most of you will have gone through this experience. This is very time and cost intensive. But not only that, if you are a software as medical device class 2A, you are required to set up a quality management system that is also certified by your notified body. And what we see by our clients' common practice is the DIN ISO 13485 certification, because it's harmonized standard for quality management systems since 2022. And this, as you all know, requires the involvement of a notified body. So we have economic tailwind, but we have clear regulatory headwind. And this is even getting stronger, this headwind, when you see, as Oliver already mentioned, that medical devices, software as medical device, which include already also an AI function, they're automatically classified as high-risk AI systems. And that means that also, not only from an MDR perspective, you need a QMS, also from an AI Act perspective, you need a QMS. So this is something that is really very burdensome, not only from an administrative procedure for supplier of AI software as medical devices, but also from a regulatory perspective. Some relief, what we have seen is through the MDCG guidance. I think you are aware of these guidelines, Medical Device Coordination Group. This is an expert committee of stakeholders from the industry, from national authorities, and also from notified bodies. They have confirmed that the interpretation of the MDR and the AI Act has to be seen like that. Once you have a quality management system under the MDR, it's not on top the AI Act quality management system. It's a complementary function. So if you have an MDR QMS, you only need to add elements to that MDR QMS with data governance, record keeping, transparency, and human oversight. So this is, in my view, at least a bit of relief, having in mind it's not a regulatory overkill, but the high regulatory burdens that providers of software as medical device with an AI function are currently suffering. So this was the update on digital health applications and the two conflicting regimes that we are currently facing. Now to this notification requirement. If you anticipate as manufacturer that you at least temporarily are not able to supply your devices to at least one member state or to the entire European Union market, then there is now a notification requirement for such situations. And another requirement I have to mention, if this interruption of supply can result in serious harm to patients and the public health. So if that is happening, you are required to not only inform the competent authority where where you as manufacturer have your permanent place of business in that member state or your authorized representative is located. You also have to inform the other members, the other economic operators in your supply chain, meaning the importers, the distributors, and also the users of your devices 6 months in advance. If no exceptional circumstances occur, exceptional circumstances are certainly incidents that suddenly happen that are out of your responsibility, like third-party service providers are running out of raw materials, components, or other similar circumstances that appear. So if that is happening, be aware that a notification requirements is applicable since January this year. Also, in this relation, we have a lot of discussions currently ongoing on an urgent need for MDR and IVDR revision. This has been started, this discussion by the European Parliament and certainly the industry associations already by a resolution that was issued in October 2024. And of course, you can imagine that it is the usual discussion. We have a huge increase of regulatory burdens for placing your medical device on the market. A lot of manufacturers still place legacy devices on the market, so MDD certified devices. And we just recently, in the meaning of 2 years ago, the transitional periods for these legacy devices have been increased, depending on your risk class, to the end of 2027 or end of 2028. But still, some manufacturers, due to the very formal and time and cost intensive conformity assessment procedures under the MDR, already anticipate that they might not be able to have finished these MDR conformity assessment procedures by then. So that's why there's currently a discussion to, for instance, get more transparency on the assessment procedures by notified bodies. We need strict timelines. We need even clear cost frameworks for that. And this is also confirmed by AdvaMed. This is also something that the US medtech industry is suffering on. So be aware that something might happen in the near future. And then also very interesting, as I believe, there is an extended opportunity now to use electronic instructions for use. And what I find quite interesting, the main trigger, of course, is inter alia, the environmental protection. And because there is a calculation which is saying that the extended use of eIFUs will save on an average of around 500 tons of paper per company, which is quite impressive, I believe. So keep in mind, eIFUs is the use of eIFUs is allowed since 3 or 4 years, but it was limited to the devices that you see here: implantable, active implantable medical devices, fixed installed medical devices, and medical devices fitted with a built-in system visually displaying the instructions for use. Now it is extended the use of eIFUs to all medical devices which are exclusively to be used by medical professionals. So that was a very quick run through. I've already get signs that I was sharp in time. Very quick run through a regulatory update from the European side, and I'm happy to hear if you have any questions. Yes, please. That's a requirement. If I recall, okay. Is there a requirement that the language is also adopted to where the layperson is located? And that's a clear yes. I think the MDR leaves some room for interpretation on this, but then the national legislators, they make very clear that the safety related information needs to be in the language of that user. But just to be very clear, MedTech Europe is currently only calling to extend this EIFU use also to layperson devices. It's a discussion that we are having. And when you see these very impressive numbers of, we say 500 tons of paper per company, I'm sure it will come in the next 1, 2, or 3 years. But for the time being, and the same applies to HCP, so exclusively to be used by professionals, safety-related information. And in my interpretation, this is more or less any kind of information in the instructions for use need to be in the user language.
Oh, just to be more specific, I was just curious about modifying the existing language because it's typically just geared to healthcare professionals. And so I was curious whether it required more modification to those instructions for the lay people to read in.
Currently, we're only talking about the EIFU,
Yes.
the instructions for use, sorry, and
Yes.
this is a document that is cleared by a notified body. So,
Okay.
I mean, I think you are referring to the discussion whether or not you can have a more scientific informational character.
Less scientific.
Okay.
So that the person who's receiving the actual device can understand as opposed to the healthcare professional. Maybe I'm getting too detailed here, but I interpreted when you use the word layperson that would then require manufacturers to modify further the instructions for patients who wanted to see. Okay.
Yeah.
Thank you.
That's a very interesting discussion, but we're having this on the promotional regime side, because when you address, when you assess whether or not an information is misleading, then you certainly have to take the view of the addressee, and someone who's not a medical expert can be much more easily be misled than an HCP. But in this respect, it's the IFU, it's a document cleared by a notified body, and you're not allowed to change the language in that, the wording of it. Thank you. So thank you very much for your attention. And now I'm handing over to Mark, and very much looking forward to the GC panel.
Talking about some of the subjects we covered today with our esteemed panel, who will introduce themselves in just a moment. We do have lunch out there, and maybe I'll just ask you to wait to grab that, but I looked at it and it looks fantastic. It was difficult not to start grabbing an egg salad sandwich out there. And then we're gonna have a Kahoot game as well. And if you're wondering what that is, who's played Kahoot? Okay, it's like an online kind of game. Do we have a prize for the winner? Top 5 get prizes. What are we playing for? Is it a secret, maybe? Surprise? A mug. All right, you're gonna get a Gardner Law mug. That's awesome. Maybe we'll go out to the bar and fill it with something for you. I don't know. So yeah, we have a couple prizes. It's kind of fun. Everybody likes a competition. You want us to move, or are we okay? Come this way? Okay. All right. How's that? Thank you. How are we doing, Charlie? Do we want us to move over a little more? Or are we good? Okay, great. Okay, I'm gonna pivot a little so I can See you guys. Thank you. Thanks for joining us here. We've got Bernie, Darcy, and Mike, and I will allow you each to introduce yourselves, but these are tried and true veteran GCs that have worked in the Valley as MedTech GCs for many years, and they are very intelligent and amazing people. Mike and I go skiing every winter together, for example. We have I'm just pre-selling a little bit of a program we're gonna have in Snowbird again, which some people in our office described as like a junket, if whatever that means. But we actually have a very lively conversation about issues like we described today with the folks from Salt Lake. There's quite a rich biotech and medtech industry actually in Salt Lake City. I think Charlie wants you to, oh, your mic, okay. So just to pre-sell a little bit, we will have a CLE out in Snowbird in late April, like it's basically the last weekend or so that they are open, and it's a lot of fun. But let's focus on today. Very excited to have you all here. And tax deductible, thank you, Mike. Yeah, just tell your boss you need to go to a really important meeting in Salt Lake to help protect the company, and you might go, on the snow with us, have a little fun. So Mike, maybe I'll have each of you introduce yourself, starting with Mike.
Amazing and intelligent people, plus Mike, the ortho bro. So
And Mike is my we co-chair that meeting together. So
my name is Mike Pisetsky. I work at a company called SI Bone down here in the Valley in Santa Clara. I've been with the company for 10 years, a lawyer by training, and now oversee our administrative functions.
Hi, I'm Darcy Teobaldi. I've been in the Valley 4 years, coming on 5, and I've been in MedTech about 20. Been interesting to see the evolution, especially now with AI coming into our space more and more.
So Bernie Shea, I'm principal at Süme Law, which is a very small law firm where I work with medical device startup companies doing GC, fractional GC and fractional patent. And I've been in the Valley for 20 years now, worked for J&J and multiple startup companies, including Cala Health, which I'll call out here as a great company. Anyway.
Yeah, awesome. I'm going to hold on to this microphone because yeah, I'll be asking some questions here. I'm going to we have an order here. We have 5 main questions with some sub questions, but I'm going to start with you, Darcy, because I was like, why don't we have Darcy first?
I thought I was lucky.
I put you right on the spot. So I do think this is a good one to start with, and it's around, we're talking about AI and how it can be used with, how to help you with your healthcare compliance, which I would define as your AKS, and this is the land of acronyms, right? So AKS, anti-kickback statute, FCA, False Claims Act, because I won't be saying the whole word from here on out. But it's your healthcare compliance is, how your sales reps who, they get us all in the most trouble, right? The salespeople and the marketing people, they always want to sell more. And so they're going to be aggressive and they're not bashful about it, right? So what can we do when we're using AI to help with our compliance? I'll just read the question. What's been most effective in keeping compliance programs agile as digital tools like AI accelerate development cycles?
Yes, so I mean, that's an interesting undertaking. One of the things that our IP team, which Teresa Raymer is here with Recor Medical, as well as Gray Palmer, have done has been able to be in the room with our R&D team to make sure we understand what they're undertaking, and then go help them find a way to do it appropriately. For example, we have a dedicated server with an AI program on it that's outside of anything else within the company or going outside the company that they could, I'm going to say play with, but they can develop with. And that way, we're making sure that they're doing it in a captive space while they're still working outside. I don't know, what else, Mike, have you seen?
So I think the area of greatest success we've had, and I'll give a shout out to Claudia Cibrian here from SI Bone, our director of compliance. We implemented a tool that oversees T&E or helps us with oversight of our expense reimbursement, right? Huge areas was talked about earlier this morning of fraud and abuse risk is abuse of your expense system. So the tool scans every request for reimbursement, all the receipts that comes in. It's going to catch duplicates. It'll catch things outside our meal limits. We've been working with the model to develop more intelligence around what's reasonable with alcohol. And, you know, that paired with a little more incentive in the system that we put in. And we've seen just tremendous success in terms of shrinking our meal limit violation rates, getting our T&E under control. But I think even prior to AI, a lot of this is about data, collecting and distributing the right data. And we call it sort of democratization of data. And it's not just a compliance initiative, right? This is a finance and operations initiative, but I make sure to tack compliance onto that, whatever they're doing. And they're going to be the leaders along with IT kind of naturally, but making sure compliance is at the table. So as we build a data warehouse, make sure that compliance data is part of it, make sure that the reporting packages our sales leaders are getting include kind of compliance metrics. So all of this put together, I think we found a lot of success in that area.
This is a little bit, but reflecting what Darcy said, it's kind of the opposite, which is making sure that your people are not misusing AI or using AI that they really shouldn't be using. For the example that I have is one of my clients was working on a patent application, and I said, under no circumstances use AI for anything that you're doing on that. And that almost sent shockwaves through the company. And the response I got from the board, which is always interesting, was, hey, we're an advanced company. What are you doing to us? And so, you know, you have to actually walk people through what the risks really are.
And your response was, I'm trying to protect you from losing your intellectual property, right?
Hey, Mark,
So that we have a company.
One more comment, kind of building on what you said. I mean, like I said, I've been here 20 years. I was at the beginning of open payments, right? And trying to convince companies that utilizing technology in the compliance space is the hardest sell that I've had. You know, I'm very fortunate here at Recor. When I joined, I said, I'm not joining unless I have a software to manage compliance, that we have some sophisticated ways to look at this, because I came from Thermo Fisher and I wasn't able to sell them in 2020 on implementing that across the businesses. And I was handling the open payments report for 11 businesses. And I said, there's no way we can do this in an appropriate way, knowing AI was coming, unless we do that. So it's important for everyone to figure out how to find that budget.
No, that's a great point, because I don't know if it was you, Darcy, or the CFO, or whom was signing off on the open payments data, but someone has to attest to their accuracy and truthfulness. And so you want to have it all right, you know, and if you don't have tools, it's impossible. I feel like with open payments, it's having worked as a compliance officer on a contract basis and under secondment for many clients, it's like you're never going to get it 100% accurate. It's impossible. If you have hundreds of salespeople and clinical people and so on paying for things for doctors all the time, the likelihood of you getting 100% accuracy on your reporting, I think, is near zero. So it's about having really good tools that will at least help you boost your percentage from a 50% or 60 to hopefully in the 90s, right? But obviously tying payments to whether the sales rep gets reimbursed or not is the best practice, so that they have to submit their expenses and they won't get paid unless they give you the information you want. Lauren.
You were both referencing using specific. Don't see a button or a light. There we go. You both referenced using specific software. Would you mind sharing which software you're using or whatever systems you're using?
Sure. So the one we use is called AppZen for expense review.
How do you spell that?
AppZen.
It sounds peaceful. AppZen.
I don't think our sales reps find much zen in it.
That's great. And I think Darcy had another comment.
For the open payments, or actually all monitoring of our engagements with HCPs except for the actual expense payment, is we started with MedComply, which we felt was really flexible, but they did get purchased by MediSpend, which I had evaluated in my prior lives. And we're just in the process of moving over to some of the MediSpend platforms. But I do have to say that we couldn't have done it with the small team we had if we didn't have the software, and we couldn't do the reports that we bring out to the board and the management team of this is what's happening, this is how we're doing it. And that otherwise would have taken, 3 people, probably, a dedicated time. Excel spreadsheets don't get you there.
Yeah, no. And also you can't tell if you're, hopefully this doesn't happen. I know it does happen. Occasionally the sales reps and the customer they're taking out, are they drinking their dinner or actually consuming it? I would think that maybe some of these tools will actually help you flag some of that. I don't know, Mike, if this app Zen does that.
It's not perfect, but yes, it does. And you can develop sort of custom modules or custom models within AppZen, and so tell it to look for checks, for example, where more than X% of the spend is on alcohol. And it does a pretty good job of identifying alcohol within the bill, or X dollars kind of per person. We do use MedComply as well as core data. I did sort of lump that into the AI pile. A lot of that is sort of process and reporting, but it's all part of an important stack, starting with, I think most companies use Concur for expense reimbursement. So it starts there, but then, what do you put on top of Concur?
And we're not being paid by these companies to endorse their products, but I do think it's a good plug for them, because especially if you have a lot of med tech companies now have drugs as well that they've, by acquisition or wherever it may be. And there's more stringent rules on drugs. I know we have a lot of med tech folks here, but, like pharma recently said, they're starting to tell you what kind of ethanol, what kind you can buy, right? Like that it's all the same chemical, but they won't let you buy liquor. It's got to be wine or beer. And so it's kind of interesting. I'm sure these software, someone's probably, maybe AI can even help with that. I don't know. But I think we covered the next question. Maybe the second part to this was, how do you maintain control and defensibility without slowing innovation? I don't know if anyone has any other comments about that they'd like to share.
Do you have anything?
I would say your board's got to buy in. I mean, because if the board isn't bought in, you're not going to be able to do this.
Yeah, no, that makes sense. Yeah.
I'm curious for you, Darcy, you mentioned having sort of a controlled space for using AI, and I'm curious, we've yet to really reflect the use of AI within our QMS, right? We have a compliance policy outside of our QMS, and we do use these tools, but we're not an AI heavy kind of product. We don't use it extensively within our R&D, but we're aware of this issue, that if it does become a real part of our R&D process, eventually we'll need to address it within our SOPs and our quality system formally. And I'm curious how you've
We're just at the beginning stages as well of looking at, in our industry, where could we use AI in either a med tech device or an app or anything like that. So it's been more, let's explore it, let's see what we can do, but we haven't quite gotten there to where we would be needing to go down the QMS path, and we're on the QMS evolution. I would say, having been approved 2 years ago, we're looking at, okay, when's our next larger audits, and how can we make sure that we've built the right, as you said, basis for those, and then what's the next step above those. We do have a new gentleman in the R&D leadership who is a lot more tech savvy, I would say, than some of our other leaders that were working on what we've been working on for 15 years, right? And he's looking at additional ways to go about that, and really partnering with our quality team to determine what it is. And he was very aware of the data act that we were talking about earlier, and understanding that we've got to be thoughtful about that right off the bat.
Interesting. Back to the tools. I think I'll just add my own comment here. I think we're going to see a lot of innovation coming down the pike right now. I know that I was in DC a few weeks ago at a Fidley meeting, and Viva was on one of the panels there. Pleasanton company locally here that's been a tremendous success story. and they are having they're deploying AI in all kinds of uses for copy review. I understand that they have QMS functions, because I would think, like, we've talked a lot about quality and regulatory aspects today, that the complaint handling process could probably be optimized. And how does that inform CAPAs and things like that? There's just so much that's coming. The other part of my mind, it's kind of like I got the angel on one side thinking about how we're going to keep the patient safe, and then the devil's over here, like, how can the sales rep use this to sell more, right? Like, and I heard a story yesterday from a local GC where they had they deployed a technology. It was kind of in a sandbox still with Boston Consulting Group, and it was just still in a demo phase. But they asked it a question like, how can we sell more? How can this, because it was really intended to be like a buddy for the sales rep. Like, how can I plan my day the best? And it was like, oh, you're in Red Wing, Minnesota. You should go see Dr. Sullivan. And then they were like, why? Oh, because he hasn't bought for a while. Well, what can I do to help? And it said, you should offer a consulting agreement and take him out to a nice dinner. And it was like, oh, that's concerning. So the AI hadn't really, and the GC was like appalled. And it hadn't consumed their policies yet that said you're not supposed to bribe doctors. But so I think we're going to see a whole bunch of stuff coming down the pike on sales force optimization, I would assume.
Yes, Salesforce optimization. And we're working on actually, you were supposed to make your SOP with regard to HCP interaction readable, like we were talking over here, readable by the average salesperson. Well, we're adding to it so we can train the internal AI that's going to be available to answer some of those questions more thoroughly, because we were afraid, we left this off and we left this off. We've got to make that like a 50-page document. And that's, intimidating, because we're not going to be able to issue that to a salesperson to read. Yeah,
getting them to open an email is hard enough, let alone read a policy. Yeah. Okay, I will head to the next question now. AI is a compliance catalyst. Mike, you were leading this one. How are AI systems changing the way? I feel like we maybe covered this already. Let's go to the next one. Regulatory and enforcement evolution, and Bernie leading this one. As regulators such as FDA, FTC, so again, acronyms, Federal Trade Commission, and the OIG, I think we all know them. They're the law enforcement for the Social Security Act, Medicare, et cetera. As they begin shaping regulatory and enforcement practices around AI, how do you see those expectations evolving?
So I'll just start with a little insight into how Mark reached the pinnacle of his profession and how he got his own law firm. A couple of days ago, we were going over the questions that everybody was supposed to handle, and there was a whole list of them. And I sent one in and I said, hey, I'd really like to hear about this. This is really of interest to me. I'd like to know more. And so we get the list of questions we're supposed to answer back. And the question that I had said I wanted to know more about was word for word there, but I was leading the discussion. So this is obviously a way of.
I'm blaming this on AI because it did help me prepare these questions, and so do you have any thoughts? So you want to know my thoughts on this one, maybe is what you're saying.
I do. I'll throw out my thoughts just from a GC standpoint. I think there's two questions that are going to come up. One is for all of these different entities and uses of AI is, one, are you using the tools that are available to be able to proactively spot issues? And two, are you validating those tools? And I think that leads to a very difficult position, because I think, at least in the interim, it means that your compliance function is going to become bigger rather than smaller, because you're going to be getting stuff in real time that you're going to have to react to. And you're going to have to also be able to show the FDA, OG, whoever comes in, that you were reacting properly to what the AI was telling you. So you have to validate that the information you're getting from the AI is there. So I would say that you're going to have to do two things basically immediately. One is partner with your IT group and go looking for what the tools are that are going to be available. And number two, go to your board and say, this is not This is not going to be a trivial issue, and AI is not going to come in and make this cheaper or easier. It's probably going to make it harder and more expensive in the long run.
Mike has some comments.
Yeah, I think there's a couple of really important points in there. And it sort of reminds me, started going down this road for real this year. And one of the first things we did is formed an AI committee. And we had our most kind of senior executives and all of the kind of concerned or relevant stakeholders at the table. I think, IT, HR is actually quite important, as well as obviously legal and regulatory, among others. So getting a cross-functional kind of view and governance of the process. Certain of our stakeholders, CFO, sort of look at this and say, great, we can automate, non-revenue generating functions, regulatory, we'll automate PMR. And I think to your point, it's actually quite the opposite, right? What we found is that these AI tools are great at generating content that needs review and oversight, right? So you still have the human layer overseeing what it creates, but what it's actually ought to be replacing is marketing, right? Voluminous, sort of questionable reliability content, that's where to go is the AI model. Then you need the human layer to get it right.
Yeah, no, I think you have to have that human in the loop, and that was something that the person from Viva talked a lot about. Was you really need a person involved in interpreting what AI is telling you, because I know that we have clients that will tell us we have to use it. They will ask us about how we are using AI in our annual review with them, and because they see it the same way we do. Frankly, it's a great benefit for making someone that knows what they're doing more efficient. So that if I remember when it first came out, there was a case I was responding to for, I knew it existed and I couldn't put my finger on it. And I looked through our files and I used, Microsoft's tech to try and find it. And I looked for, 15 minutes, couldn't find it, punched it in AI and it came up immediately, so there's a great use for it, but you have to have that human in the loop. And what Viva said as well is they know that because this was a Fidley's ad promo conference, which obviously focused on advertising, promotion, review, which is massive in the drug space compared to the device space. And they were like, the people on these teams won't use it if they think their job is going to be eliminated, for one thing. So they were really seeking buy-in from these committees. And yes, go ahead.
So how do you see the government using it then?
I see the government, we already see them using it to investigate what they see as fraud. So they're going through the Sunshine data. That's not new. They have stated that at meetings from the podium that they are using AI to, for example, digest the Sunshine data. And you can line that up against the prescription and service billings and whatnot. This is all, it was made years ago. It was all made public. So you can, you pay companies money to go in and chop the data up for you and make it clean. But it's all out there. And as a former product manager, I would pay for those data. And I don't know what they're doing now because I'm not buying them, but so you can look at prescribing behavior and compare it to the payment data. Are they consultants? Are they accepting grants? Are they doing research? And so that obviously we know that KOLs are all very busy, and those are the ones that are some of the ones I hired when I was a product manager. I didn't know if they ever slept. I'd see them at a meeting and ask them to do something, and I'd get it on like Friday night the next day or something. You're like, so they are kind of workaholics, a lot of the KOLs, and so it makes sense that they're going to receive the biggest payments on open payments, and that they are probably using a lot of products that they're ultimately getting have consulting gigs with, because they also have incredibly busy practices, many of them. So a couple of comments on that point, how I think the government will use it. I also think that FDA is arguably, I would love to hear Nate's thoughts on this and Amanda's, but they came out with, we're going to use AI to start to do our jobs, and there was really very, I think, little guidance around it or rigor in terms of how they were going to use data to review drug submissions, for example. And And then what happens to those data? Are they going to be lost, or are they, can people access them all corners of the planet? If you put it in this model, do we have confidence in FDA's model? Is it closed, or where do those data go? Because they're worth a lot of money.
And what about the hallucinations that come from it?
The hallucinations.
Yeah, you still need the human factor there. And that's one thing that I'm hoping still exists.
Yeah, and to that point, we have a case work with a client within federal court, and this plaintiff's lawyer who was misusing terms of art about the Sunshine Act was citing a case to support his position from 2012. And I'm like, okay, that law didn't go into effect until August 1st, 2011. So how are you citing or 2013, excuse me, citing a case from 2012 about it? But okay. All right, so let's go to the next question here. Actually, yeah. Okay, so AI meets fraud and abuse law. How might AI-driven decision support pricing algorithms, something Amanda touched on earlier, and patient engagement tools trigger anti-kickback statute or False Claims Act exposure in unexpected ways?
Well, I mean, I think your example, Mark, of the BCG initiative or tool is a great example. AI, you can't explain often the results you're getting. And what's key to these laws, the False Claims Act, the anti-kickback statute, is they're intent-based statutes, right? So if you get an answer or a suggestion and you can't explain the intent, or the intent is generate more revenue, you're starting from a bad place, right? So we haven't seen, in our company, these kind of uses like pricing strategy yet. Maybe that's coming, but again, I think the theme is these tools need human oversight. They're super useful, and I'll give one example where I think we found great effect within legal and compliance is just policy review and updating, right? Feed your policies to several different tools and compare the results, but then take what it gives you and have a human kind of reintegrate and update the policy. It will pop issues that a human might have missed, but then you need the human to actually update the policy.
I completely agree. I mean, we can't leave it on its own. I would also say, like, in the patient engagement side, you're going to build some sort of, response, right, to your average FAQs, but you have to be thoughtful about where will that response, what will be the next question and who will be managing that next question. So you can utilize it, but you also still have to have the oversight available. And those are the things that we're trying to build into our next patient engagement tools.
I think when you're in the reimbursement in Medicare, Medicaid area, there's probably a lot of opportunity for the government to go in and look at the prescriptions and how the devices are being used and how it's being, if there's a pattern of prescription language that's being used. So, if your salespeople are saying, doc, if you prescribe it this way, we know they'll get reimbursement. If you prescribe it this way, they won't. And I think there's probably an enforcement activity will come up around that.
Yeah, no, I completely agree, Bernie. And I think that was another thing that Amanda had touched on earlier on the agenda for the government, for the OIG, is they're aware. It's in some ways, I look at, I often say old tricks are the best tricks, right? Like, and you see behavior I know we have a lot of compliance officers in the room. The same things that I've seen in 1999 when I entered this industry, I see now. And I'm like, how are you so dumb that you did this to the sales reps? And I can throw a lot of shade at them because I worked in commercial roles for the first 10 years of my career. But, and the same goes for this coding aspects. I mean, there was I think it was Insys that was, in order to get prescribed, I'll finish the sentence. I think it was Insys whose sales reps were just filling out these prior auth forms and whatnot for drugs that they had. And I think it was for treating cancer, pain associated with cancer, if I remember right. And, they did some of the review on them. Again, I'm not an expert on this case. I haven't read it for a while, but they didn't always have cancer, the patients. The reps were just filling that part in, and so I would be really careful if you're using AI to support your patient's access to your therapy, whether it's a drug or a device, to make sure that the algorithm isn't just filling out the form so that Aetna or whomever pays for your drug or device, because that's called a false claim. If they don't indeed have cancer and you're trying to get the government to pay, or a private payer for that matter, to pay for the drug to treat cancer or pain associated with it, well, then that is like the definition of a false claim, isn't it? So I think, Bernie, that's an excellent point, where you have to really vet these tools to make sure that they work. And I've had several clients where there's access issues with new technologies, right? If you're going to get an X-ray this afternoon, that's been around a while, not really an access issue for a patient. But if you have some PMA device or NDA drug, it hasn't existed, so no one wants to pay for it until everybody agrees that it works. And so it's very tempting to deploy tools and work with vendors that will tell you this is going to help you solve that issue that you have with access. And if it's really cheap, that's a red flag. Like, I've reviewed some of these with Paul and others on our team. And if it's like, wow, it's only $5 a prior authorization, it's like, well, that's because a computer is doing everything. There's no human involved. And they have no, privacy program or compliance program. So you really have to be careful with those. Any other comments on that?
I mean, I think a lot of it goes to what's the role you put it in, right? We shouldn't be filling out medical necessity or writing medical necessity justification, period, whether or not it's a computer or a human. So are you putting the AI tool in the right role, right? So we have an AI, or we have an initiative to use sort of AI tools within our reimbursement function, but you got to be very careful about the role you put it in. So they can certainly review the patient file, kind of flag areas, but at the end of the day, the letter has to go back to the doctor, and the physician has to, or the physician's office has to draft it and sign it. So we can help, and we can have the AI tool parse a 500-page medical record, but at the end of the day, neither we nor an AI tool that we deploy can be in that role.
That's a really important point that Mike's making. Tracy's letting me know I have 5 minutes. We have 5 minutes left. If there's any audience questions, we'd love to take them. We have more, probably some that Bernie asked me about that he wanted to know the answer to. But in all seriousness, we've designed and worked with clients. We've gone in and audit these programs, and we often find it's like, oh yeah, of course we're submitting it for the customer, and yeah, we're logging into their system and doing it for them, and it's like, well, time out. If anything's wrong here, you are, every time you do that, potentially incriminating yourself. So you want to be really careful with those aspects. But and I'll just say one last thing about it, because I've asked Mary Reardon about this one-on-one at conferences where I've said, are you still allowing reimbursement support? Because you can read the AdvaMed code and it's very clear. It says you can. And Amanda sat on the working group to draft that section of the code. And Amanda, I think there's some people, I think Allison Shuren, Dr. Shuren's wife, was on that committee with you. And there were some views on that committee that said we shouldn't do this. And there were other views that said we should. And I think you all decided not to change it. But it's a controversial topic. It's one of high risk, because you have, and again, what I'm describing is helping the patient get access to that drug or device when it's very expensive. And how do you ease that pain for the provider? And one of the ways is you're going to help the patient get access through these tools, right? But be careful with those tools, because they invoke FDA, HIPAA, AKS, FCA issues, all of them, so they're really high risk. But I asked Mary, is this still okay? And her response is basically exactly what AdvaMed said. As long as it's not tantamount to a inducement, it's fine. It's like, okay.
But I think one of the things that you're speaking to is you need to have the other controls in your company. Like how do you review vendors? How do you review the contracts? How do you review IT tools that your vendor is going to use? And that's something that is hard when you're a startup and doesn't have a procurement department to kind of flag it. So it ends up in the legal team, in which we say, hey, wait a minute, you want to contract with these people? Or we've looked through our vendor data to try to keep an eye on it. And we find, hey, maybe you're not using the right vendor there, or you didn't come to legal to make sure that we've identified all of the potential risks with this particular project. And sometimes you end up having to say, let's slow down, let me give you a speed bump, and let's go back and take a look at the intent and what exactly are you trying to do. But I think AI is only going to speed up those services coming to market, and you have to be mindful of your procurement path.
Yeah, absolutely. I think we've like scratched the surface on what's coming in terms of commercial use of AI and how that's going to gain them more sales. Like for example, GEO. There's SEO, right? That's kind of like old fashioned now. Sales optimization engine, search engine. Thank you. And now it's generative engine optimization, which is for LLM models. And so you keep an eye on your people, because they'll probably be starting to put things out and it only reads HTML and it likes Reddit a lot, like ChatGPT and whatnot. So, if they say we're posting things to Reddit about our competitors' products and our products, all of that needs to be obviously reviewed. And that's happening right now. That's where the drug industry is going. So it's, Google right now, they're saying, oh, you're going to have to break it up because you have a monopoly. They're like, we don't care. This is old tech. Nobody who Googles anymore. Once you get bit by ChatGPT, which by the way is destroying the planet apparently because it's creating heat and using tons of energy, you'll stop using Google because it's way less efficient. ChatGPT actually answers your question. There's no ads. But I'm sure that will change with their multi-trillion-dollar public offering, or maybe it's not multi. I think it's going to be the biggest public offering ever next year for OpenAI. So I was going to ask you, Bernie, because you've got some connections in the Valley here. I know that. Any comments or questions from the audience? I think we're pretty much at time. Maybe one more. Any questions, comments, or we want to have lunch? All right. Well, please join me in give me a round of applause for the panel here. Thank you.